gadgets right there. So he said, the best. I said, look, the water's only $1.50.
Good for 145. Please rise. The Justice of the Appellate Division, Supreme Court, First Department. He, all persons having business with the Appellate Division, draw near, give your attendance, and shall be heard. Please be seated.
Good afternoon. Welcome to the Appellate Division First Department. As I call the calendar today, please ask for the time that you actually need. And remember that the panel, if it has additional questions past the time you've been allotted, we will ask them, and you'll have an opportunity to answer. We've read your papers and are familiar with the issues that underlie your appeals. For those of you here for the first time, you should know that the white light on the lectern will go off when you have 2 minutes left, or if you've asked for less than 2 minutes, it will go on immediately. When I call your case, rise and let me know how much time you are requesting. People versus Danny Naboa.
Respondent requests 3, Your Honor.
4 and 1 and 3. Henn versus Sewell. 5 and 2 and 3. D. Brandon is submitted. 110 NCLC v. Bank of America.
Appellant cross-respondent requests 12, 8, and 4.
Who are you here for?
Respondent and cross-appellant Bank of America requests 4 and 1.
I'm going to give you all 5 and 2. PSNY XREL Tobias.
Appellant requests 10 and 3. Respondent requests 10.
Let me give you 6 and 2 and 5. People versus James Park. Excuse me.
Appellate requests 9 and 3.
Respondent requests 8, please.
I'll give you 7 and 2 and 6. JTE D46 Incorporated for Espresso Dream. I'll give you 3. Thank you. Pelagia, if I mispronounce that, I apologize, v. KPNY Operations. Okay, I'll give you 3. D. Parvati. Give you 5 and 2 and 4. Sire Spirits versus Beam, Suntory.
Good afternoon, Your Honor. Appellant requests 10 and 2. And 2 appellees that represent Dean and Mr. Fishman represents inclusive defendant. We have 5 each.
Okay. I'll give you 6 and 2 and 5 and 5. Thank you. Dowla versus Professional Staff Congress. Yes, sir.
I'm here for the respondent, Polka.
Well, the appellant's not here. Do you want to be heard briefly?
Not if Your Honor's going to. We'll be here for briefly. 5 minutes, Your Honor.
It looks like there's no one who has any particular questions. Counsel, it's your call. If you want, I'll give you 3 if you want.
No, thank you.
Okay, submitted. Next case is Torres versus Levy. Justice Shulman will be recused on that one. Anybody else here? Do you know?
I was told last night that they would not be appearing today.
Which appellant are you here for?
Dr. Daniel Basilelli and Dr. Amit Kalra.
Oh, both of them.
Both of them.
Okay. Very well. I'll give you 3 minutes. We have Davis versus Schlayer.
For the appellant, 5 and 2, please.
We may take a little more time with that, but we'll start with 5 and 2 and 5. Thank you. Okay, first case up, People versus Danny Naboa.
Step up.
Oh, should I call it in? Counsel, just give me a minute.
Okay.
Yeah. Is anyone here on Covenant House versus Drysdale? Submit. All right, counsel, give me a minute, a second. You may proceed.
Thank you. Good afternoon, Your Honors. I'm Liza Batkin from the Legal Aid Society. I have the privilege of representing appellant Danny Naboa. It's been nearly a decade since Mr. Naboa was caught with a gun in his waistband. He was 20 years old. This led to his first and only criminal conviction. And everyone agreed that Mr. Naboa deserved to avoid prison. The only question is how long he needed to be on probation. 5 years is too long.
How much time is left on his probation now? Just a few months, right?
He has 4 months left on his probation, so it's a modest request, and it may not seem like a lot of time, but to Mr. Naboa, it's a tremendously long amount of time. He's working full-time. He has to visit his probation officer 3 times a week. He has a young daughter. The conditions of probation, while they served a very important function, are now making it harder for him to lead the law-abiding and productive life that he is currently leading. There are other mitigating factors that diminished Mr. Naboa's likelihood of committing other crimes. He has committed no further crimes. He has strong family support. I'm a mother, a stepfather, as I mentioned. He now has a...
Now, the fact that it was his first felony conviction, that was taken into account by the sentencing judge, though, wasn't it?
Yes, it was, and this court has the opportunity to re-examine and consider whether a shorter sentence was appropriate. And as I said, we really are asking for a very modest...
So, counsel, did your client waive his right to appeal?
He did. The appeal waiver was invalid.
Oh, okay.
Yeah.
Right, because normally if he waived, you wouldn't be here. So tell me why you think
Yes.
why the waiver is invalid.
For a couple of reasons. For one, the court never accurately characterized its scope, never told Mr. Naboa any of the legal errors that he would still be able to raise, including the validity of the plea, legality of the sentence.
Well, so counsel, the trial judge said there are certain issues, including constitutional issues, that defendant could still appeal, and the trial court confirmed that he had discussed those issues with his attorney, correct?
Yes.
And you're alleging that that's not sufficient?
I'm alleging that in combination with the other errors of the appeal waiver were not sufficient.
Okay.
So we also need to remember who Mr. Naboa was. He was 21. He had never pled guilty to a crime before. There's no indication he had ever seen an appeal waiver before. And even if the appeal waiver may have been valid as to barring certain other claims, it did not bar this particular claim because the court never explained that he was giving up his right to raise an excessive sentence claim. It told him that he would be barred from raising errors.
Did the written waiver discuss excessive sentence?
Yes, the written
And did
waiver.
the court ask him whether he had read the written waiver and discussed it with his attorney?
Yes.
And you're still arguing that wasn't sufficient?
Yes, Your Honor. It was the court's obligation to ensure on the record that Mr. Naboa was pleading knowingly and voluntarily to waive his constitutional right to appeal. And again, Mr. Naboa had never seen an appeal waiver before. So an appeal waiver that may have been valid for another defendant, may not have been for Mr. Naboa.
Counsel, would you not agree that he had exposure potentially on this charge from 3.5 to almost 15 years, minimum maximum sentence, and he was given a real gift of 5 years probation to be able to go on with his life, except for checking in when he had to check in. He had a full and fair opportunity to be with his family, full and fair opportunity to be able to look for employment and do all the things that you believe you would like him to do. So you don't see that was a gift in that context?
May I respond, Your Honor?
Please.
He was very grateful for that time, and we're grateful that everyone agreed that probation was the correct sentence for him. The question is really just how long, and it's our contention that 5 years is just a little too long for a defendant like Mr. Naboa, who has been thriving in the community. Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the court. Reva Grace Phillips for the respondent, the Bronx County District Attorney's Office. Defendant validly waived his right to appeal, thereby foreclosing his excessive sentence claim. In any case, defendant's sentence was very fair. As Your Honors highlighted, he received somewhat of a gift in his plea. The only reason that this plea was allowed to go forward, in fact, was that the people provided mitigating factors to the sentencing court. The sentencing court heard those mitigating factors, the very same factors defendant now raises on appeal, and agreed with the people's generous non-incarceratory offer. Unless your honors have any questions for me, I'll cede the rest of my time.
Thank you, counsel.
Thank you, your honors.
I don't have much more to say except that I do want to reiterate that Mr. Naboa's mitigating circumstances were very powerful, and while taken into account by the trial court, we're asking you to take them into account again in determining what was a proper sentence. Mr. Naboa has paid the price for his sole criminal conviction. The purpose of probation has been served, and we're asking this court to recognize that by modestly reducing his sentence. Thank you, your honors.
Thank you very much, counsel. Thank you both. Henn versus Sewell.
Good afternoon, Your Honors. Stuart Gold for petitioner Brian Henn.
Counsel, give me a moment.
Sure.
Please. You can go ahead.
Stuart Gold, appearing for petitioner Brian Henn. We ask this court to reverse two of the police commissioner's findings that Mr. Henn, a police officer, committed misconduct. The finding that Henn made inaccurate statements should be reversed on two grounds. First, Henn's conviction for inaccurate statements rests on uncharged conduct. Specifically, the charge was that Henn made an inaccurate statement during an interview by failing to acknowledge that he had sent a text to a colleague on December 17, 2020.
But wasn't the judicial hearing, the JHO who heard the testimony, considering the evasive nature of his response to whether he sent that particular text with the I don't know, the
What do you mean?
pornographic or picture. I'm not going into details, even though the record is clear what was description. And eventually, he came up with it. Well, I didn't have context, but you don't think there was a basis for that kind of charge and how he was responding to what was improper?
Right. So he was charged with making an inaccurate statement, but an inaccurate statement under the NYPD's guidelines is giving incorrect information. The more appropriate charge would have been a misleading statement, but it's not inaccurate to deny that I sent someone text messages on a certain date if I didn't actually send those messages on that particular date.
Can you repeat? I'm sorry, I didn't understand that. Can you repeat that?
Meaning, Henn was charged and convicted of making an inaccurate statement, and the underlying statement was that he was asked in an interview whether he had sent a colleague certain text messages on December 17th, 2020. But the texts were not sent on December 19th. They were sent on a different date than what he was asked about. So therefore, it wasn't giving false information. He wasn't required to correct the investigator's question. It could have been misleading, but it certainly was not inaccurate.
Are you saying that misleading can't be inaccurate?
Right. If you look at the department's guidelines, and this is attached to my opening brief.
What about the fact that he said that he couldn't recall sending the memes and then later said, oh yeah, I do recall sending the memes?
Well,
couldn't that be
even on a bare transcript, what Justice Garpula is describing sounds like prevarication, and we weren't even in the room. And of course, there's a great deal of deference given to the hearing officer concerning the credibility of the witnesses.
Right. So I think the credibility is separate and apart from whether he was convicted of uncharged conduct. And again, at most it was misleading, but not inaccurate. And it's also irrational to find that it was misleading because he was questioned about this 9 months after he sent the text, and he wasn't given any context to it.
Let me ask you about a separate question, which is that Mr. Samuel, of course, was he had a duty as a mandatory reporter, right?
Right.
And you complain about that, and in your reply you say you weren't able to find surveillance videos, but the behavior complained of is texts and things he said. So how would a video have helped your client?
So what I was referring to was the discriminatory remarks that my client made. So he was convicted of making an inaccurate statement, and those are the memes. And then he was also convicted of making discriminatory remarks, which is the other conviction that we're
And those were
challenging on
captured
appeal.
on surveillance video? I'm sorry, I missed the...
Right, inside the precinct. So if Sergeant Samuel would have made a timely report, the first alleged discriminatory remark was made in December 2019, and Samuel did not make the report until 6 months later, and there's no...
Wait, are you saying that there are cameras in the locker rooms? There are video cameras in the locker rooms?
So one incident happened inside the precinct by a station.
No, he said we were sitting in the locker room. We're 2 lockers from each other, and that's when he made the discriminatory comments, right?
There are three.
And you're saying that the prejudice for not immediately reporting it was that you couldn't get the locker room video?
There were 3 separate incidents that my client
Let's
was...
focus, let's focus on the one where he said, we're 2 lockers away from each other. I'm complaining that you only get overtime because you're Muslim, right?
Right, so the...
And you're saying the prejudice for not reporting that right away was that there was locker room video?
No, I wasn't referring to surveillance footage for the locker room incident, but if he would have reported it timely, the person who said that hadn't made the remark in the locker room said that there may have been someone else in the locker room, and so the department could have potentially found this...
Well, why couldn't you do that 6 months later? The same, unless you're saying everyone got fired in between the time of the comment and 6 months later, why couldn't... Why is the time stop the department from looking for the people who might have been at the locker room that day?
Because that's the whole purpose of why an alleged discriminatory remark must be made timely, and the record shows that the reason is because so that the department can locate potential witnesses.
Right. Oh, I have no qualm with that. You're just saying you were prejudiced, and I can't figure out what the prejudice was, because 6 months later they could have looked for other people who might have been in the locker room that day, right?
Right, but
and then you're saying that you didn't get any video, but I have a high degree of skepticism that there was video from inside the locker room.
Right, so first, the department's investigator testified at trial that if the report was made timely, they could have located and asked, or potentially located and asked witnesses, and the fact that it was not made timely was the reason or a reason why they could not find any witnesses. And again, the surveillance footage I was referring to the incident that happened by the station house desk. I'm not referring to the locker room. I'm just, in general, all these incidents, they could have located and interviewed witnesses to see if these accusations were true or false.
Thank you, counsel. You have time in rebuttal.
Thank you.
May it please the court, Jeff Kerfman on behalf of the respondents. The police commissioner properly found the petitioner guilty of making inappropriate remarks regarding the skin color and religion of other officers and of making inaccurate statements during a department interview. This court should affirm. Beginning with the inaccurate statements, the trial commissioner appropriately found Henn guilty of making inaccurate statements during the interview. He reasonably found that these memes were sufficiently distinctive that the petitioner would have recalled sending them, particularly given his concession and evident memory that he had not sent them to any other officers. The petitioner's argument, raised for the first time on reply, that NYPD somehow violated his due process rights by convicting him of uncharged conduct, is both unpreserved and entirely meritless. The trial commissioner reasonably found that the petitioner's statement that he could not recall sending the memes was inaccurate as charged.
Can you address counsel's argument that he was prejudiced by the fact that the one of the complainants didn't bring a formal complaint for several months after the alleged statements were made?
Certainly, Your Honor. The argument of prejudice here turns on testimony from an EEO investigator that Saeed and Samuel had made general comments that the petitioner made derogatory remarks in front of groups of in front of groups of other people, but there was no testimony from the EEO investigator that Saeed and Samuel made the told him that the petitioner made the remarks at issue in this case in front of other groups of people.
So I want to ask you, whose burden is it is it your burden to show lack of prejudice, or the petitioner's burden to show prejudice?
Your Honor, it's our understanding that it would be the petitioner's burden, but in either case, he certainly has not shown any prejudice here because he has not shown that there were any identifiable witnesses in the area. Saeed and Samuel were clear in their testimony that they did not recall seeing any other witnesses in the vicinity.
Doesn't that sort of reinforce your friend's point then, that a prompt report was required to allow for a full and thorough timely investigation, or because in this instance where they weren't able to recall whether anyone else was around, all the more reason for a fast reaction to the complaint and a thorough investigation as to who may have been in the area?
Your Honor, the EEO policy at issue here in no way restricts the commissioner's authority to hold the petitioner, to find the petitioner guilty for making inappropriate and discriminatory remarks. Rather, the rule states that the mandatory reporter has an obligation to timely report, and the consequences for failing to timely report are discipline against the mandatory reporter. And that makes sense in light of the purpose, a core purpose of the rule of protecting employees and victims of discrimination from ongoing discrimination.
Thank you, counsel.
Thank you.
So regarding the prejudice, in the trial transcript at page 97, the EEOD investigator specifically testified that some of the allegations that were made by Sergeant Samuel and Officer Saeed were made in front of groups of people. And moreover, on pages 98 and 99, the EEOD investigator testified that if an EEOD complaint would have been made timely, then the department would have been able to figure out who was in the vicinity. So it's totally unfair for Hen to have basically defend against allegations within a 6-month time period, and the failure of Samuel's timely report made it impossible for the department to find any corroborating witnesses.
Well, I mean, he was there, right? If he could have gone out, he was one of the people who were there. So he could have thought to himself, gee, was anybody else in the locker room or in this place or that place, and could have interviewed those witnesses himself, right? It's not like this happened. These are other people who did this. He could have done the same thing.
Well, first of all, he was only made aware of the complaint after the EEOD complaint was
I agree, but
filed.
you're saying the prejudice was that no one could interview these people because they don't know who they were. But he was there at the time. If he thought there was somebody else who was there at the time, he could have interviewed that person himself, right?
Right, but Hen denies these allegations, and specifically one of these discriminatory remarks, story the trial judge found was totally incredible. So Hen denies that he was in the place where the complainants testified that he was. So it was impossible for him to find any witnesses. Second of all, it's also the department's burden to prove Hen's guilt, and it just made it impossible for him to sorry.
Counsel, I'm sorry. The hearing officer heard the testimony of Mr. Saeed, Mr. Samuels, Mr. Hen, and it really rests on questions of credibility. As my colleague pointed out, we weren't in the room, they were in the room, get to weigh how they answered questions. Yes, there were certain inconsistencies, but overall, the hearing officer, in an extensive fact-laden report, found that Saeed and Samuels heard what they heard or received what they received in the context of discriminatory statements and text messages and the like. So what could we possibly do here?
Right, so in general, credibility findings are unreviewable, But in this case, there were glaring inconsistencies between in the complainant's testimony, and the case law provides that testimony that is incredible as a matter of law cannot be substantial evidence. And just to give one or two examples.
Counsel, thank you. We have your brief on that point. Thank you very much. Thank you both. (110) NCLC v. Bank of America et al. Please.
Good afternoon, Your Honor. Honors, Peter Fox on behalf of 110 NCLC. I'll start with the appeal. The issue on the appeal is limited to a damages waiver in the loan contract, in the loan agreement, which I'll refer to by its section number 18.6.
But, you know, as they point out, we're talking about paragraph 18.6, that's where you're starting?
That's correct.
Yeah, so the opponents, your opponents both point out the word discretion does not appear in 18.6. So how do you support your interpretation?
Well, so 18.6 doesn't purport to cover every single claim against a lender. It purports to cover only claims against lenders for breaches of obligations where the lender is required
Counsel,
to
can
act
you pull
either.
the microphone a little closer to your mouth? Thank you.
Is this better?
Better, yes,
Okay,
thank you.
18.6 is limited to breaches of lender obligations where the lender is obligated to act reasonably or the lender is obligated to act promptly. We would submit that the breach at issue in this case, the breach of an obligation to release certain reserve funds on a particular date in a particular amount, does not involve an obligation to act reasonably and therefore is not susceptible to an unreasonable action, nor does it involve an obligation to act
Because those
promptly.
are strict timelines you were saying about those two payments.
Yes, that's correct. And I would point the court to, you know, the only two cases that we're aware of, although they are both from out of this jurisdiction, involving breaches of lender obligations to release concrete amounts of funds on dates certain. In both of those cases, I'm talking about the NNN case and the CFPB case, the lender and servicer, or lender or servicer, argued that an substantially identical damages waiver applied, and in both cases the court disagreed. If I may briefly address the argument that the respondents have made in their brief as to promptness, they argue that the obligation to make a disbursement on a particular date, in fact, is an obligation to act promptly, and they cite the second definition in Webster's dictionary as to what promptly means, which means on a precise time, like I was here for oral argument promptly at 2 p.m. But that's not the way that the term is used in the loan documents, and that's not the way that common sense would indicate the term is used. There are scores of references to prompt obligations in the loan documents, and they all mean to act when a certain condition
arises. Should promptness be measured by the prejudice caused by the delay at all?
I'm sorry, can you repeat that?
I'm sorry, should promptness, as we're defining it here, be measured in any way by the prejudice caused to the person who, in this case your client, who did not receive the funds?
I would say no. I mean, I think...
Was there prejudice to, you mentioned, what was the prejudice caused by these slightly
The
delayed
prejudice
payments?
was the loss of use of the funds for approximately 2.5 months, and we're talking about nearly $2 million.
But you got it back with interest, right?
No, we did not receive interest. And that would be the quantum of damages. And in fact, it goes to, in my view, the problem with the trial court's interpretation that anytime there's a delay, 18.6 is implicated, because it's exactly when there's a delay in this type of circumstances that you need damages, because that's
No, that's the statement itself to which your client agreed is, in that circumstance, here's your remedies. You can get a declaratory judgment, right? Or but you're not getting money damages. That's what we agreed to. It's a pretty straightforward and pretty common thing to put in an agreement like this. Banks often do this,
Well,
so that we don't have this kind of argument here.
Your Honor, I would disagree. I think the purpose of the damages
I
waiver
guess that's
is
right. We disagree
yeah,
on that, but
is-
I think it's pretty straightforward.
is-
I think when it says you can't get money damages, it means you can't get money damages for delay.
right, but that
And they absolutely delayed putting the money into your other account from which you could draw money. But they did do it 2.5 months later. And the whole point of that is to prevent you from claiming money damages, right?
may I respond
Please.
very briefly? I mean, first, I would say that only begs the question as to what types of obligations does this waiver apply, and that's where I started the argument. But beyond that, I think that the damages waiver has a very clear purpose. There are scores of provisions in this loan agreement and in the other loan documents where the lender has an obligation to not unreasonably withhold consent. It is in those instances where the lender has discretion.
Does it say anything in that provision about that being the only situation in which one can claim, or the bank can claim that you're not entitled to money damages?
Absolutely, I would.
Where in that does it
if you
say
wanna-
only in this situation may you not
Yeah, well,
read it to me?
okay, so if you look at page 13 of our opening brief.
No, I don't want your brief. I
Okay.
want the document.
Okay,
I want
all
you
right,
to
so,
read the document, that section, 18.6. Where does it say in this circumstance?
Okay, I'll read the entire provision.
No, I don't.
Okay,
Again.
All right,
Not
the
necessary.
the operative language
over
would be.
the time. I
would
just
be-
want you to say
okay,
where those words are in. Are those words in that 18.6?
Where the lender has an, quote, obligation to act reasonably or promptly.
That's not what you just said, right? But okay, thank you.
Very
You have time in rebuttal, counsel.
Thank you.
Please.
Good afternoon, Your Honors, and may it please the Court, Brian Kusid, K&L Gates LLP, on behalf of the Wells Fargo and Wilmington Trust defendants. Briefly, with respect to Mr. Fox's argument on Section 18.6, even if you look at the first definition, which they cite promptly in on page 12 of their reply brief, it's defined as immediately and without delay. And the only allegation here on the breach of contract claim is delay.
Got it. Why don't we move on to some of the other issues, counsel?
Sure.
So since this is a pleading motion,
Yes.
why doesn't the plaintiff make out its case, by, on his part performance claim, that would avoid the oral no modification, no oral modification provision? Sorry, that's not a very articulately stated, but you know what I'm talking about.
Great question, Your Honor. I think the key here, and what makes this case admittedly somewhat unique, we did a heck of a lot of research to try to find other cases that dealt with a complaint that pled the facts that are pled here. And it's pretty unique because what the plaintiff's allegations essentially are is you waived or modified the loan documents by course of performance, but all of that course of performance occurred subject to repeated reservations of rights. And that's throughout the complaint at paragraph 65, 72, 85, 103, 113 of the complaint. So when you...
I mean, for starters, before you get to the reservation of rights letters, you got the Carrie Henderson email, right? That was in January.
Yes, there is an email and there is an alleged oral modification followed up with an email.
Kind of memorializes a new regime about how the money should flow, right? I mean, it says that.
That is what they allege. I'm sorry for interrupting, Your Honor.
No, please.
That is what they allege. But if you look at the email itself and compare it to the actual language of the loan agreement at issue, Section 2.5a, it just tracks the language of Section 2.5a of the loan agreement. So there's not a distinction between what...
Are you saying that that email is, the way the money was dispersed was exactly the same way that it was in the loan documents?
Yeah.
Yes, or yes, or...
Well, I'm
the allegation is, after that email, the money never went into the secret lockbox document. It went into our operating account so that we could start paying our bills every month, right?
That is their allegation.
That's the
yes.
allegation. Let's assume that's true. And it seemed to me that that is not an unreasonable interpretation from the language of the email. And that, in fact, occurred over the next 2 years, right?
That is their allegation, yes.
Right. And so the question then again is, why isn't that sufficient to allege a performance modification of a document that has a no modification clause?
Well, I think a couple of reasons. First, as I said, that's not the full extent of the allegations in the complaint. The complaint isn't limited to just that allegation and the Carrie Henderson email that Your Honor noted. It goes on to acknowledge that at multiple occasions over that same stretch of time, my clients reserved their rights under the loan documents and, in fact, noticed defaults under the loan documents for failure to comply with the cash management procedures. So when you're looking at a contract that has, or multiple contracts here, that have repeated no oral modification, no waiver provisions, and this court has said in Gans and Paramount Leasehold that a heightened pleading standard applies there, you need more than just one citation, especially when combined with repeated reservations of rights. And I think the repeated reservations of rights, which they don't dispute were sent, and in fact they rely on the fact that they were sent in their complaint, makes this a different case than what would typically be the case if it was just there was an oral modification and there was an email follow-up, and that's enough to...
And no calling of the default.
sorry,
No calling of the default for 2 years. 2 years you're accepting this new way of doing business. Every so often sending out a notification that says, oh yeah, by the way, we're still... So I guess my question is, that's more of a defense than a 3211A7 motion or A1 motion to dismiss. Your defense is we didn't accept your the modification. We kept telling you not to do it, although you never called a default in the 2 years, right?
I think...
This was going on for 2 years. Am I correct about that? That's the allegation.
The allegation is that it's gone on for
2 years.
more than that.
And every once in a while, you sent out a notice that we still reserve our rights, but you never called a default.
Well, can I answer?
Please.
A default was called later on, yes.
Because the fund was lowered at a minimum, there was a minimum level that it went under.
That was one basis of the default.
That was a major basis.
If your honors look at pages 252 to 253 of the joint record, that's just the first reservation of rights letter that was sent just a few months after the Carrie Henderson email that was referenced, that specifically says the borrower failed to comply with the cash management procedures. We're not waiving any rights with respect to the cash management procedures. We urge you to comply with those without delay. And I think what sets this apart from a typical case where a pleading might be sufficient to create a factual issue is that all of this is pled together. And when you have a reservation of rights that's been repeatedly pled at the same time that they're relying on solely course of performance, there's no alleged signed agreement changing the loan documents, that's a different case. And we, in our view, don't think that meets the heightened pleading standard under the law.
You did make that point in your brief.
you.
You have time in rebuttal. Thank you. Wait a minute, actually, Bank of America first. Thank you.
May it please the court, good afternoon, Justice Higgett and Justice Scarpula, Justice Moulton, and Justice Shulman, and Justice O'Neill-Levy. I was perfectly happy to remain seated because Bank of America really has no role whatsoever in this case. I'm going to rely on Mr. Kuset's argument on the breach of contract issue, and I will address the 3 declaratory judgment actions, causes of action that remain. Yes, Justice Shulman.
When you assigned everything to Wilmington, was there anything in the assignment that totally released you, Bank of America, of any kind of liability on this record?
We assigned all of our rights and obligations and delegated to Wilmington as trustee all of our rights and obligations, and the plaintiff, 110 NC, in the loan agreement consented to that by signing the loan agreement because their consent was not needed.
Can you cite us, like chapter and verse, give us a record citation to where Bank of America had there's some language that absolves it from all liability under the loan documents?
Excuse me, Judge, I didn't hear the end of that.
Can you cite us a place in the record where Bank of America is absolved from all liability under the loan documents?
There is no language specifically absolving Bank of America under the loan documents, but however, here, there is absolutely no controversy between the plaintiff and Bank of America. The basis of the declaratory judgment claims are that plaintiff, and this is alleged in the complaint, I think it's paragraph 28, the basis of the declaratory judgment causes of action against Bank of America is simply they have some concern that at some point Bank of America will try to enforce its rights sometime in the future. That does not meet the CPLR 3001 standard. There is no present controversy, there's no certain controversy, and in fact, in their brief, their main brief, they devote 14 lines in their brief without saying anything about what any sort of present controversy is or why there's a declaratory judgment needed from Bank of America. Now, this loan closed on October 29th, 2020. On that date, Wells Fargo had already set up the lockbox account, and from that point forward, even before the assignment, every dollar of rent went into the lockbox account. All of the disbursements came out of Wells Fargo's account, no account at Bank of America. The dispute is about a free rent reserve, which had nothing to do with Bank of America. Plaintiff claims and alleges in their complaint that they are a beneficiary of every assignment made by Bank of America. Why is that the case? It's the case because this transaction, which was a collateralized mortgage-backed securities transaction, was a very large transaction, $280 million, 7 notes. It was the new world headquarters of McDonald's Corporation in Chicago, and it was going, this loan, along with others, were going into this trust. Plaintiff alleges they were the beneficiary of all of the assignments made in order to establish that trust because it wouldn't have happened if this transaction had not occurred. So they didn't deal with Bank of America at all. They closed the loan and they immediately, even before the assignment, started dealing with Wells Fargo. Every dollar of rent that was paid was held in an account, and this is what was contemplated. It was contemplated in the loan agreements with Bank of America that they signed. They were a customer of Bank of America, so they got the loans through Bank of America, but they knew, and that's why they plead that they were a beneficiary of the transaction. They knew that it was going into the CMBS trust. Wilmington was the trustee. Wells Fargo was the servicer and had to deal with everything that came after that with respect to servicing the loan. That's why there's no present controversy supporting any declaratory judgment claim against Bank of America. Thank you.
Thank you very much. Lynn, if you have 2 minutes, can you talk about the assignment and why it should not absolve Bank of America?
Yeah, sure, Your Honor. I mean, it's black letter law that if you delegate your duties to perform, that may create an obligation to the delegee, but it doesn't absolve you of your obligations unless the obligee executes a discharge or a release. And there was no discharge or release of Bank of America in this case. I mean, it's really open and shut. Staying with
What
Bank of
about
America-
counsel's argument that there's no present controversy? You have no claim.
So Bank of America remains a party to the loan agreement. Bank of America has rights under the loan agreement. It's alleged that Bank of America assigned rights under the loan agreement to Wilmington Trust as trustee, but it's not alleged that that assignment was exclusive. It's also alleged that Wells Fargo is an agent. They are a servicer, sort of the quintessential agent of the lenders, including Bank of America, and Wells Fargo has been threatening enforcement under these provisions of the loan agreement. May I speak very briefly about the cross appeal? So first, with the Kerry Henderson email, this is a pleading case. We are entitled to favorable inferences. If you read that email in the context of the rest of the complaint, including the preceding paragraph, that the parties had a teleconference and agreed on the phone that they were going to change performance, and you read it in the context of the other allegations, paragraphs, I believe, 44 and 46, that even in advance of this email, the parties had changed performance, I don't think there's any way you can look at that email and not see it as—
In the reservation of rights letters, they just create an issue of tribal fact?
They do, Your Honor, and there's really only one that gets to the issues in this case. The other ones are letters that have boilerplate reservations of rights. One of them is about making a deposit into an account. The other one has to do with the account balances. None of the cases that the cross appellants cite have anything like, at least as far as I can tell, this type of course of performance and oral agreement to go along with the reservation of rights, which were in a vacuum in those cases.
Thank you very much.
Thank you very much.
Briefly, Your Honors, Mr. Fox just noted the account balances, account deposits that were the subject of the other reservations of rights letters. Those are all part of the cash management procedures that are entered into as part of Article 10 of the loan agreement, the deposit account control agreement, and the cash management agreement. They're all facets of the cash management process for this loan. As I believe Ms. Kaufman noted, these are about the most sophisticated parties imaginable, and these sophisticated parties agreed for a loan for $180 million that there would be clauses for no oral modification, no waiver, any departure by the borrower, any consent to a departure by the borrower from the terms of the loan agreement had to be in writing, signed by Wells Fargo. There's no signed writing here, and given the heightened pleading standard, again, we don't think that the facts as pled, accepted as true, including the reservation of rights that they admit we sent, suffice to meet the heightened pleading standard for waiver or modification or termination as a matter of New York law. And I also just draw the court's attention to cases that we did cite in our brief, the Second Department's decision in Krugman and this court's decision in National Resorts, both of which deal with reservation of rights issues on a 3211 motion and not deferring those to summary judgment. If there's no further questions, we'll rest on our papers. Thank you, Your Honors.
Thank you, counsel.
I don't have a lot, Your Honors. Mr. Fox alleges or states to you, it is alleged, as if it's an allegation coming from us. The complaint is what alleges it, his client's complaint. And there is not one word in this complaint of wrongdoing by Bank of America. There's not one word of any sort of misconduct or failure to do anything by Bank of America. And he alleges, again in paragraph 28 of the complaint, that as servicer, Wells Fargo was delegated the duty of making these disbursements, meaning paying the free rent. There is perhaps a controversy between Wells Fargo and the plaintiff over this, which you've discussed
So
already.
let me just ask you, if somewhere down the line, the trial court finds that there was a modification of the loan agreements, isn't that an issue, such a declaration, isn't that going to be binding on you?
Anything that happens would be binding
So
on us.
isn't it better that that you can argue against that? If that's why you want to be out of the lawsuit, if somewhere down the line the loan documents are modified, I would assume that Bank of America would want some say in that.
Bank of America's view is, as stated in the assignments, that all of its rights and obligations have been assigned. It has delegated all authority, And in this type of transaction, that is what is customary. Bank of America may have rights under the trust, but with respect to the loan agreement, the cash management agreement, and the DACA, they have assigned all of those to Wilmington.
So when your friend mentioned that you weren't given an actual discharge, does that have any legal meaning at all?
Not as to him, because he signed a loan agreement that contemplated we were going to do this. He knew exactly that it was going to be transferred into a type, his clients, into this type of trust. Thank you.
Thank you all. People of the state of New York, ex-rel Tobias. This is not Park. Yeah. Please.
May it please the court. Sarah Coco for appellant, the New York State Department of Corrections and Community Supervision. For more than a year, DOCS has been attempting to hold a final hearing in this parole revocation case. Gillard has consistently failed to appear for a final hearing and has accrued supplemental charges.
No, he was not the most compliant parolee, that is true. But that's not the question in front of us.
That's correct, Your Honor. So the question in front of the court is whether the Less is More Act, LEMA, altered DOCS's authority to bring supplemental charges after a preliminary hearing has already been held.
The first question we have for you, I guess, is the question of deference. Isn't this just pure statutory construction? It has nothing to do with the expertise of the agency. Wouldn't you concede that?
We would disagree, Your Honor. We do think DOCS is entitled to deference here because this is the agency that administers the statute, which is typically a basis for deference. And in addition, the question here deals with DOCS's
But this is just math. This is just looking at a calendar and figuring out when things are supposed to happen. So I don't see the deference.
So, Your Honor, we believe deference is due because this has to do with DOCS's operational practices and procedures.
Listen, as a practical matter, I could see why DOCS would not be so happy with this schedule, but it's there. And we don't get to go around what the statute says concerning when you must do the preliminary hearing.
So, Your Honor, we believe that we should prevail whether or not deference is given to DOCS because we believe this is also the plain interpretation of the statute, but we are arguing that DOCS is entitled to deference. And we would refer the court to the Woodley versus Poole case from this court from April 2024, which granted deference to OCFS on the procedures due to its hearings because that had to do with the agency's procedures and practices. And so we think this is an analogous situation. But in any event—
Now, can I ask you then, how do you distinguish People versus Annucci, which we recently decided on this exact issue in not in DOC's favor?
That's correct, Your Honor. So in People versus Annucci, I believe the court concluded that DOCS's interpretation was contrary to the text of the statute. And we're arguing here that our interpretation is consistent with the text of the statute.
I know, but so haven't we already decided this? Are you asking us to ignore another panel of this court that is—
I'm sorry, on the issue of deference or—
No, just on whether or not you've timely complied with the statute. The statute says what it says. I don't think there's any doubt. We all— it looks pretty straightforward. There are time periods by which you have to hold the parole revocation hearing, and this one wasn't, even though you held one on a previous warrant 84, right? You didn't hold one timely on warrant 85. I don't think that's under the statute anyway, right? And you're asking us to sort of extend the warrant 84 hearing to warrant 85, and didn't this court in Annucci say we can't do that?
No, Your Honor. So Annucci did not have to do with supplemental charges, and this is a very different situation than Annucci, so I just want to be clear about that. Prior to Lima, it was well established that DOCS could bring supplemental charges after the preliminary hearing that had been blessed by appellate decisions as cited in our brief, and the legislature is assumed to have enacted Lima with that existing practice in mind. And so the question is, did Lima change DOCS's statutory authority in that respect? And the answer is no. Gillard is relying on this provision that says, for any alleged charge for which a court issues an order detaining a person, a preliminary hearing must be held. But in context, that word "any" should be read to distinguish between—
I'm sorry to interrupt you, but which provision of the executive law recognizes supplemental charges?
So, Your Honor, supplemental charges are not recognized in Lima, but I want to be clear, they were not recognized before Lima either, and yet it was clearly established that DOCS could bring supplemental charges. And so that practice was already established, and you can see in a case like this why allowing DOCS to bring supplemental charges would make sense.
What was the underlying purpose of Lima, in your view?
So as we explained in our brief, there were several purposes. One was to change the consequences for so-called technical charges. In addition, the legislature intended to streamline the parole revocation proceedings to shorten the entire timeline, and then to ensure that some individuals would not be detained pending that final parole revocation hearing. And that is consistent with the interpretation we're offering here. So under our interpretation, an individual will have a shorter period of detention pending that final parole revocation hearing. If you adopt Gallard's position and assume that docs cannot bring any supplemental charges, then someone like Gallard is going to be subject to at least 5 separate periods of detention for these 5 separate sets of parole violations. That could be up to 35 days in detention for each separate set of charges.
Except then you do the hearings if you do the hearings timely, right? Then many of those charges are going to be resolved during that period of time. And so 85 was new charges plus the old charges, correct?
That's correct. Because
why not just bring the new charges? Why leave 84 as it is and bring 85 with new charges? That would resolve your problem about, or your belief that the supplemental, it's the same charge, right?
It's not the same charge, Your Honor. So we had the original charges, he absconded.
Some of the charges were charged before, correct?
There was the original charges. The supplemental charges are all based on new conduct, to be clear.
Right, so then how is it supplemental if they're new? Because I thought 85 contained some of 84 plus new stuff.
So the second warrant was supplemental charges, but they were based on new conduct, so it was not the same conduct as the original charges. And the reason they're supplemental is because no final parole revocation hearing had been held, and DOCS's burden at the preliminary hearing is to show sufficient evidence to proceed as to one or more of the charges. So it's well established that DOCS does not need to show sufficient evidence to proceed on all of the charges in order to proceed to a final revocation hearing. And so these are supplemental charges because they can also be proved at the final revocation hearing. There doesn't need to be a separate hearing on each set of charges.
Thank you, counsel. You have time in rebuttal.
Good afternoon, Your Honors. Legal Aid Society by Michelle McGrath on behalf of Mr. Gillard. The matter before the court is quite simple. Under the newly enacted Less is More statute, the legislature mandated that if a person is detained at a recognizance hearing, they must receive a preliminary hearing within 5 days of the recognizance hearing. The statute could not be more clear. It states—
Mr. Gillard got some habeas relief prior to this habeas relief, correct?
That is correct, Your Honor.
What was the basis for that?
That the first basis was that he was being detained longer than the punishment for which he could receive, which was 7 days. The second time he received habeas relief, it was because he was not permitted to challenge a charge which would subject him to incarceration or allegation, and that is, it's a constitutional violation.
Thank you.
And what do you think of counsel's argument that if we interpret it the way that you are advocating, that this defendant would actually have been in 5 times?
I think that's inaccurate, Your Honor. So I think, first of all, the amount of time, there's a provision in Less is More that says any time assessments have to be run concurrently. So if there were separate cases, it's not that he would get a lot of them. The other issue here is that every time DOC seeks to re-detain a person, they have to justify that with a preliminary hearing. And so if a person is at liberty and then they come back into custody, what the legislature was attempting to do was to ensure that DOCs had evidence, because that's what a preliminary hearing is. They have to provide evidence, right? And so if they had simply provided a constitutionally sufficient preliminary hearing in the first place, then we would not be here. And that's sort of the problem, is that every time And Mr. Gillard's case is unique. In some cases, a person may have been released at a recognizance hearing. A judge found that they should have been released. And then perhaps there is a subsequent violation. And if there is a subsequent violation, we're not saying that docs can never arrest anybody. All we're saying is that the person gets the process that was clearly mandated by the legislature, which says that the department shall afford a person a preliminary hearing anytime there is an order to detain. What docs attempts to do here is evade the obvious and plain meaning of the statute through an invocation of this concept of supplemental charges. But the premise of their argument is contrary to the language in less is more itself. The statute does not permit them to add supplemental charges after the conclusion of the preliminary hearing. Certainly they may add them up until then, but the legislature removed a provision of the law that said as long as there was 14 days notice to a final hearing, of course, then you can add charges. And it is when the legislature removes something, it is a canon of statutory interpretation that that removal has to mean something. And what the legislature did was remove the 14 days and say, actually, go back and look at the provision. It redirects us to the provision that says you have to serve all of the charges at the conclusion of a preliminary hearing. Docs cannot serve notice of charges which have not occurred yet. That's why this is a new proceeding, because there are entirely new charges. And the legislature said, if you haven't served the charges at the conclusion of the preliminary hearing, and you want to rearrest someone, then you arrest them, you follow the procedures that were in the case. And I want to be clear, our argument is ultimately not about supplemental charges, but the plain text of the law and what happens when there's a new order to detain. Indisputably, a new order to detain was issued, and his liberty was at stake. Mr. Gillard was arrested on an arrest warrant. Docs followed the statutory rules for issuing that warrant. It followed the rules for providing a recognizance hearing. It then simply refused to follow the rule that upon an order to detain, it must provide a preliminary hearing within 5 days. A hearing with actual evidence that would justify the allegations, which was detaining person. And contrary to their argument, this would not upend the system of parole. It would simply require docs to do what it already does hundreds of times a week across the state, which is to give people preliminary hearings after they've been ordered detained. And had docs simply followed the law, Mr. Gillard would have stayed detained pending the disposition of his parole matter. All petitioner asks is that docs do what it already does hundreds of times a day, give Mr. Gillard a preliminary hearing. The statute is clear. For any alleged violation for which a court issued an order detaining a person within 5 days, the department shall afford such person a preliminary hearing. The court need not look further, and it should affirm the decision below as it is in accordance with the plain language of the statute and the express will, decarceral will of the legislature.
Thank you.
I'd like to start with the basis for the previous habeas relief. So if you look in the record at page 7, this is Mr. Gillard's own habeas petition, and he says that in March he was granted habeas relief on the grounds that the charge that docs went forward on at the preliminary hearing would not subject him to incarceration. So he's recognizing in March that that previous preliminary hearing applied to these supplemental charges. And so I just want to be clear. Second, Mr. Gillard also recognizes that docs had authority to bring supplemental charges prior to Lima after the preliminary hearing. That's in his brief at page 11.
But maybe your friend agrees that docs is free to bring additional charges in the future. But I guess this packaging of supplemental prior to Lima had a certain clear and obvious administrative consequence, and that is they could all be pursued provided the detainee had notice before the final hearing. However, we've gotten away, your friend, if I understood her argument, that by virtue of certain amendments and deletions from the statute, the legislature was signaling we wanted to get away from this colloquially referred to supplemental charges, and now we just have the charges.
So that's not correct, Your Honor. And if you look in the record, or excuse me, in the statute at section 259, IC 3C Romanet 3, that's the notice that is required at the recognizance hearing. And it says at the recognizance hearing, the individual must receive notice of the charges. So that actually happens at the recognizance hearing and again at the preliminary hearing. And then they must receive notice of the preliminary hearing Or if no preliminary hearing is required, they must receive notice of the final revocation hearing. So the legislature was recognizing that in some circumstances, no preliminary hearing would be required. And that's exactly what happened here.
Is that only circumstance where there would be supplemental charges, or are there other circumstances where a hearing wouldn't be required?
There are multiple circumstances, but one of them is where there would be supplemental charges. And if you look in the record at 101, that's exactly what happened here. So Schlayer had a timely recognizance hearing. Docs gave him notice of the charges, including the supplemental charges, and they scheduled a final revocation hearing for only 19 days later. So if Schlayer had simply had that final revocation hearing, this whole thing would have been closed. But instead, he was released, and that's why we're before this court.
Thank you, counsel. Thank you both.
You.
People versus James Park. Please.
May it please the court, my name is Ron Kuby. I represent the appellant James Park. And while it took a fairly winding road to end up here today, the case itself actually presents a fairly straightforward issue as to applying the constitutional speedy trial jurisprudence of Wiggins and this court's jurisprudence in McDonald. James Park spent 5 years, 1 month, 22 days in pretrial detention during the worst of the worst times at Rikers Island.
Well, you say, let's talk about COVID first as being an excuse for the delay. You know, COVID-19, there's no constitutional exclusion, you say in your brief, for COVID-19. However, you must acknowledge that there were some impediments to bringing people from Rikers to 100 Center Street during COVID.
Okay, so yes, obviously, we can't ignore that. But jurisprudentially, there are ways to address it. Number one, Wiggins pointed, and we'll consider COVID to be a neutral principle, or it certainly would be neutral if we were doing a 30-30 analysis. But we're doing a 30-20 analysis, and Wiggins made it clear that in a 30-20 analysis, so-called neutral factors, such as court congestion, still bear constitutional significance, because they are actually happening to the person.
But they're still excludable to a degree, are they not? In other words, they're still excludable from the time that's taken.
Right. There's no constitutional exclusion. However, we live in a real world. And so it's clear that between March 2020 and March 21st, 2021, cases could not be tried. But in this case, we don't have to address that question because the prosecution still was required to do during COVID everything that they could do to be ready for trial. So by the DA's own admission, the prosecutor was able to get back into her office in July of 2020. And that gave her plenty of time to prepare, assemble, and serve the new law discovery, which she never did, to file a certificate of compliance, which was never done, to file a statement of readiness, which also was never done. You may get some time, right, because you can't try cases during COVID-19, but it's not a license to sit on your couch and watch Netflix for a year and do nothing while somebody is in Rikers Island.
Well, there was of course, there was the original trial that happened. The original trial, the first attempt at a trial, which had to be adjourned because of the sickness of the.
Well, that's right. There was an attempted trial, and indeed, Mr. Murphy fell ill. They reconvened on January 23rd, and at that point, the first thing the prosecutor said was, "I have a case in March." So the judge said, "All right, well, you know, we'll put this on for April," and of course, April didn't happen because of COVID. But even after the pandemic ended, the prosecution, with an amazing ability, which, I mean, frankly, as a defense lawyer who does a lot of obstruct and delay himself, I was dazzled by the prosecutor's ability year after year after year to delay, to adjourn, to set control dates, and then on those control dates, there may be other cases that need to be tried, and seek another control date, which went on for 5 years.
Do you want to speak to several times on the record, either the court or the DA's office spoke of 30-30 cases and that the clock cases. Do you want to speak to that privileging 30-30 cases against constitutional cases?
Sure. The district attorney is an elected official of the state of New York. And the district attorney has a right, an absolute right, to prioritize the things they choose to prioritize. There may be political consequences for that, and we've seen a lot of talk about that over the many decades, but that's his right. But that doesn't mean that James Park, sitting in a jail cell in Rikers Island during the worst of the worst dysfunction, has to bear the brunt of that. You make a choice. I don't want less serious cases to be dismissed. Fine, that's your choice. But you can't ignore, or at least you should not be allowed to ignore, the constitutional speedy trial rights of a defendant.
So
And that's
what,
was
counsel?
going on here. I mean,
May I ask you about preservation?
yes.
Are you saying that every moment of this time you are claiming is preserved? Because I think we're looking at least 500 days that are not preserved for appeal.
I'm not following you. I thought we were going to talk about preservation of their arguments.
No, your client made a pro se motion, correct?
Yeah, so is he limited to the time periods identified in that motion?
Right. So he made a speedy trial motion in November of 2021 complaining about all of the time that had taken place so far.
And he didn't appeal from that, right?
No, he didn't. And he did not appeal.
So is there not a preservation? Well, I will say, the people argue there's a preservation issue.
I'm sorry. Just back up a little bit, and this undoubtedly is my confusion. The initial appellate brief did not contain that argument when it was filed and argued before this court. Subsequently, new counsel, i.e. me, filed a petition for writ of error coram nobis. This court granted that petition for writ of error coram nobis, limited to the issue of the very claim I'm bringing now.
That doesn't mean that the preservation issue goes away.
What else was Mr. Park supposed to do to preserve his speedy trial claim? He's objecting a couple of times in the course of the case. He obviously hires a lawyer to ghostwrite a fairly sophisticated motion that the prosecution does not respond to when it's filed, doesn't respond to on February 14th, doesn't respond to on March 22nd, but the judge rules on it.
Right, and there's no requirement that the DA respond. Is there any requirement that the DA respond? The judge ruled on it, right?
Right, the DA doesn't have to
let
respond.
me ask you, in the pro se motion, did the defendant raise the time period January 29th through November 9th? When I went through it, I saw 500 days that were not raised in his pro se motion below. And you can't, just by filing a coram nobis motion, you can't avoid that.
I understand that, but he raised, I did not read his motion to encompass anything other than all of the time that he had been detained. I read his motion, and the court clearly read his motion to indicate that this encompasses all of the time from the time you were arrested on January 29, 2017, up until March 22nd, 2021, when the court is ruling on the motion, considers the motion, denies the motion. They don't have to respond, it's true, but they don't get to make arguments now that they should have made below. And to me, honestly, that's the real preservation argument they never bothered to answer.
Okay, thank you, counsel. You have time in rebuttal.
May it please the court, Amanda Regan on behalf of the people. To pick up with the preservation issue, the people didn't respond to defendant's pro se motion for two reasons. The number one reason is, as stated on the record in February 2022, the people never received a copy of that motion ahead of that date. Defense counsel handed it to the prosecutor in the courtroom that day. But then subsequently, defense counsel declined to adopt defendant's pro se motion. And so the people had no obligation.
The court ruled on it, correct?
Yes, the court did rule on it. However, the people, at the time that the ruling was made, trial was just about to begin. It was actually on the first day of trial.
And now on appeal, are you arguing that there is a preservation issue with part of the time?
I'm sorry?
Are you arguing on appeal? You're arguing now on appeal that there is, part of it was not preserved, part of the period of time was not preserved?
Yes.
Because of the pro se motion?
Because defense counsel never adopted defendant's pro se motion, and because of the substance of the pro se motion, yes.
Okay, and so you're arguing for 500, approximately 500 days? Or not? Okay.
Yes.
Or at least that's how I read it.
Okay.
Okay.
But turning to the merits, defendant's constitutional speedy trial right was not violated. Within 2.5 years, his first trial began, and unfortunately that ended in a mistrial because of defense counsel's illness. When the court reconvened the case in January 2020, defense counsel was actually still ill. And it wasn't until March 2020, March 5th, 2020, that defense counsel returned to court. So to say that
doesn't that make it, those delays, don't they make it imperative that this case get tried?
Yes, but
I mean, this is 5 years and change, living in Rikers, during COVID.
No,
the immiseration behind that is very bad. So why weren't people jumping up and down and getting this done?
the people couldn't have been expected to be ready to go to trial on March 5th, 2020, because we didn't know that defense counsel was going to be representing defendants still. And then it was adjourned, I believe, for a month to get things in order to start the case, the trial, and then the COVID-19 pandemic hit. And for the entire period from March 2020 to March 2021, all jury trials were suspended. Bench trials were held in very limited instances, and defendant never waived a jury trial. And then even after we
Also,
returned,
the defendant made it clear from early on that he wasn't going to plead, right?
Exactly, yes. This case was sent to Part 94.
But how does that cut? I mean, doesn't that create greater impetus to go to trial?
I understand Your Honor's point, but the people at defense counsel and the court were all working together to bring this case to trial. There were delays.
Well, obviously, the defendant didn't think so because he filed a pro se speedy trial motion.
Understandable, but the defendant also was a cause of some of that delay. He refused to come to court on it.
Yeah, but there's nothing in the record that says on the day that he didn't come to court that his lawyer waived his appearance. So that couldn't have. I mean,
not at every one. On October 25th, the defendant's case was set for hearings. He refused to come to court that day. The case was adjourned to October 30th, and a force order was issued. Defendant appeared pursuant to that force order, and then on the very next court date, when hearings actually began, defendant refused to come to court. And it bears note that he, on October 30th, 2018, said, you know, I want a speedy trial, and then on the very next court date, refuses to come to court. He can't have it both ways. He can't come to court when he wants to, and then demand a speedy trial when he feels that it should be demanded.
I mean, how do you address the extended delay in giving over the discovery?
That's another area where that is unpreserved. First of all, under the old discovery laws, Article 240, that was all handed over by trial. With the Article 245 discovery, on March 5th, 2020, defense counsel filed a letter with the court that waived any objection to the timing of that Article 245 discovery. And he repeatedly said he was not objecting to the people's request for more time to comply with discovery.
Yeah, in that same waiver, he also waived speedy trial time too, right?
Yes, he did.
So who was interested in moving this forward? Did anyone at any point in this have an obligation to make sure that this moved forward? Because I think, and at McDonald, Justice Shulman and I were on the McDonald case together. I may ask you about that in a moment. But at some point, someone or some bodies have to be interested in moving this case along, even if others in the equation are content with the churning over of the case.
I understand Your Honor's point, and I think everybody was concerned with moving this case along. The reality is both defense counsel below, the people below, and the judge below had very busy schedules, and they were combating those busy schedules with trying to fit this in. And in between, defense counsel was ill. Defendant was refusing to come to court. The COVID pandemic hit. Everybody was working together to try and get this case to trial, especially once we returned from COVID. I mean, there's evidence in the record to suggest that the chief administrative judge had a trial expediter who herself sat down with the parties and tried to schedule this case for trial and still struggled to do so. So everybody wanted to move this case along. It's an unfortunate reality of this case that the pandemic hit and did extend the time it took to take this case to trial.
Justice Higgins, did you have another question you wanted to ask?
I was just going to ask if you wanted to address McDonald, because I know there are some similarities here, and it obviously was in your friend's brief, so I just wanted to give you an opportunity to distinguish McDonald if you could.
Sure, I think McDonald is distinguishable from this case because in McDonald, a large part of the reason for the delay was that there was a reluctant witness who didn't want to come to testify, and then this court found that he didn't come to testify ultimately, and this court found that his testimony was not necessary to bring in the statement, which was the people's position that his testimony was required for. And here, there is no such reluctant witness or hold up because we're trying to build a stronger case, as in some of the other cases cited by my adversary. Here, the challenges with scheduling this case was the sheer volume of and the complexity of this case. We had over 20 witnesses, over 200 pieces of evidence were admitted. Scheduling that number of witnesses for a 3-week trial, particularly post-COVID, where jurors are still anxious to come to court and getting a juror who's going to sit for 3 weeks, when social distancing measures are still in place, are all significant challenges that I think the record bears out that everybody was working together to bring this case to trial and to overcome those challenges.
Thank you, counsel.
Thank you. We ask that you affirm.
They did receive the motion in November, and we proved that. They never even bothered to check the mail records, the certified mail records, to see if they got it. But in my reply brief, spent $16.05 on an official U.S. government website.
Counsel, given like the perfect storm of circumstances here that delayed this case, isn't it an important factor that weighs against you the fact that there were 25 witnesses, and it did take, I think, more than 3 weeks to try the case? It was a complex case.
It didn't have to be. They decided to, and I know some of you have read the record before of the original appeal, they decided to lord up the case with every text message, every email, a lot of completely extraneous witnesses in the case, when the only real evidence in the case, the substantial evidence in the case, was one eyewitness who did not see, who saw the fight in its entirety, but didn't see the knife, and a videotape. They did, again, they can try the case any way they want. They can make it last 3 weeks if they want to make it last 3 weeks. They can call 50 witnesses if they want to call 50 witnesses. But when you have somebody who during his first attempted trial, had been in jail already for 34 months without the people ever answering ready? I don't think that that's acceptable, and I think that does not count in favor of the people.
Sir, I'm sorry to interrupt you, but would you mind addressing the fifth factor of Taranovich and Wiggins, the impairment of the defense?
I can try. Historically, there has always been the requirement of case-specific prejudice for factor 5. And that's usually been the shoals on which these cases have consistently foundered. But in Wiggins, borrowing from federal jurisprudence, they introduced the concept, which this court embraced in McDonald, of prejudice to the person, presumptive prejudice. And that's a very, very real form of prejudice. So I don't know if that's viewed as another factor, whether that is viewed as factor 5, whether that adds additional weight to factor 4, which is incarceration. That I can't sort out. But the law is quite clear that when you spend 5 years on Rikers Island during the worst and worst and worst of the times, getting sick and being isolated and not having family and friends being able to visit, that is presumptive prejudice.
Thank you, counsel. Thank you both. Okay, JTE D46 via Espresso Dream.
May it please the court, I'm Eric Berry for the appellants. There were two contractual provisions at issue. One was a contractual warranty that all sales taxes from the seller's period of ownership had been paid. The other was a contractual promise that if the warranty turned out to be incorrect, they would be paid, and both were breached. There's really...
Sir, your client or counsel before the court had the option. You could either seek rescission, correct, or go forward with the jury trial on recapturing the sales tax that you had to ultimately pay. You opted for rescission, correct?
I don't believe that we should have been forced. There's two decisions that are really relevant here. The first is Deerfield v. Cheeseboro, Court of Appeals in 1986.
Did you object timely?
Pardon me?
The judge made you elect between...
That's correct.
Did you object timely?
Yes, we did.
Wait, didn't you send a letter in saying, I'm going to choose to go for the rescissionary damages?
We were told...
How is that objective?
That's where we were told we had to do that, but at the conference...
You have to choose one theory of recovery or another, right?
At
trial.
At the conference. Well,
you're saying you can go for two completely inconsistent theories of recovery at trial?
There's a letter... I'm not understanding what the point is being made by the court. In the record, there is a letter where I say specifically that we have the right to do both. The judge rejected that, okay? I'm not going to fight. At that point, I told her that I wanted the transcript so ordered so I could appeal it. That's what happened. What the law is that I wasn't properly required to choose between the two. You not only have two separate provisions, but you have two separate fact patterns. The Court of Appeals has addressed a specific situation. The case is Deerfield against Cheeseboro. It holds that damages for both fraud and breach of contract are permitted where the claims are not duplicative.
That's not what we're talking about. We're talking about rescissionary damages, which assumes that the contract doesn't exist or should be voided, as opposed to breach of contract damages, which embraces the contract and alleges damages for a breach. Those are completely different theories of recovery.
No, that is absolutely incorrect.
Okay.
Breach of contract is a claim. Fraud is a claim. They sometimes overlap. Sometimes they're based on different facts. Sometimes they're based on the same facts. But when they're based on different facts, you can bring them both simultaneously, even though the same contract's involved. We cite half a dozen decisions, some by this court, which specifically hold that. Now, the question is, when are you forced to choose a remedy? The answer, the correct answer, I believe, is you're not forced to choose a remedy, especially if there's a bench trial. What happens is, when everything is said and done, do you get duplicative damages? Of course, you don't get duplicative damages. It's at the point of entry of judgment that the court is required to make sure there's no duplicative.
Thank you, counsel. You make that point in your brief. Thank you very much. Ayush Paleja, the KPNY. Counsel, is the correct pronunciation Paleja?
I believe it is.
Thank you.
May it please the court, my name is Emmanuel Katayev. I'm of Sage Legal LLC, representing defendant appellant KPNY Operations LLC.
Can we talk about Mr. Mulchandani to start? What do you got against him, or what's in the complaint about him?
There's
Is it
really
enough? It is the question, of course.
There's really nothing in the complaint against him except that he put a stop payment on some checks, but he did so at the direction of the managing member, or at least the complaint.
Is there any allegation that he got the money himself from the stop checks?
There's
Anything
no
like
allegation
Just
that he had any
did,
self-interest.
okay.
None. In fact, when the complaint allegation provides, the plaintiff's complaint allegations provide that plaintiff confronted Mr. Mulchandani about this, and he said, there's a disagreement with the minority member, Pradeep and Annika, and your shares were not approved. He didn't make the decision that the shares were not approved. He is stating what the direction was from above, from the majority member, Kailasa. If he was told that that's the case and he acted at their direction, there is no plausible inference that could be made that there was any self-interested dealing by Gary. He was
just acting as an officer.
Exactly, and therefore the complaint against him should be dismissed. I see there's no questions about the operating agreement and the motion to dismiss for KPNY. The only argument the plaintiff makes is that there was apparent authority. But apparent authority by Annika, who's a self-interested party in receiving $60,000 to pay for a wedding for her sister that her father needed the money for. You can't have apparent authority based on a self-interested member.
I mean, you can. That's your defense to it. But this is a pre-answer motion to dismiss, right?
The operating agreement is so clear. It says that.
But he doesn't have a copy of the. He doesn't.
It's his fault, Your Honor.
He doesn't have a copy of the
company, and you don't want to ask for the
Don't talk over. Don't talk over.
I apologize, Your Honor.
Please.
What I am saying to you is, someone comes to him and says, I want to purchase your share. Do you want to purchase my shares? The shares have her name signed on them on the back. She is an officer and a shareholder of the company, and you might say in your answer that reliance on the fact that she's a self-interested person who is going to get that money vitiates the apparent authority, but we're not at the answer claim yet. We're just at the complaint stage.
Well, a few points on that, Your Honor. First of all, if you are a party to this lawsuit and you thought it was important to get an attorney for this lawsuit, you should have gotten an attorney for the deal. He did not get an attorney for the deal.
Someone buys shares, people buy shares all the time in corporations without getting the operating agreement, without getting an attorney involved.
Setting that aside, he knows that he's buying 5 or 10%. The obvious question is, who owns the remaining shares? Don't I need to speak to them? He did not do any due diligence, and that should not fall on KPNY. What's important here is that the plaintiff was harmed. I will concede that, but the plaintiff was not harmed by KPNY. The Malhotra defendants harmed him. They received the $60,000. The complaint makes that clear. KPNY did not receive that money. KPNY didn't receive anything. All KPNY received was a headache and attorney's fees during the height of COVID, and it has nothing to do, it has no dog in this fight, and it shouldn't be a part of this. The complaint against
Counsel, thank you very much. We have your brief. I gave you 3 minutes, even though the other side is not here. So thank you very much.
It's a privilege.
Okay, in the matter of Parvati.
Good afternoon, Your Honors. May it please the court. My name is Claire Merkin, and I am from the Legal Aid Society, and I'm here on behalf of the child Parvati D. This case raises the question of whether a parent who has abused or neglected their child should be afforded greater rights and privileges than a parent who did not. Specifically, it's whether a parent of a child who had foster child who has turned 18.
But your client is a child under the Family Court Act because she has agreed to stay in the foster care system. That's section 1087A, right?
That's correct. The definition of a child also defines as a person between the ages of 18 and 21, but that's the purpose, the purpose of this is to get the child's consent to remain in foster care. So it's to make sure that the child knows and that they can leave if they want and to get their consent to be able to remain. It does not amount to any waiver of rights or to any decision.
But it sounds, I mean, from the statutory scheme, as you know, the argument is that that appellation of being a child means that necessarily the father or the parent, a parent, gets notice. And there's no way around that.
Well, there is one, the family court uses child as a blanket term for all of those persons who are under the age of 21. But over the age of 18, as the consent provision recognizes, the child needs to provide consent because once they become an adult, there is a panoply of rights that then they're entitled to at the age of 18. And these includes the right to privacy, they includes the rights to make decisions for themselves, to determine where their life goes, and to determine who is privy to information and who can affect their life. And when they appear for these permanency hearing and they're over the age of 18, and especially in this particular case where this child whose goal is not return to parent, but the equivalent of independent living, it's called alternative planned permanent living arrangement. The parent has nothing to
So let me just ask you about that. Doesn't Family Court Act 1089 define a child as a person who consents to remain in foster care between the ages of 18 and 21?
Yes, but that...
So that's what, there it is. It's not an amorphous thing, it's defined in the Family Court Act. Your client, sadly, or in a, look, I mean, we all feel for her, but the act says what it says. She's defined as a child under the act, under the statute that 1089B1, the father, because she's defined as a child, gets the notices.
But the relationship, the rights and privileges between the child and the parent, once the child becomes an adult, are not implicated.
Exactly. This is what I'm saying. For the purpose of this statute, your client is defined as a child, not an adult.
I understand, but as a child for purposes of remaining in foster care, not for purposes of giving up their rights as an adult.
So
they have rights
what
as adults.
provision of the Family Court Act or any other law or case or regulation, what normative authority would allow family court or us to give you the type of relief that you're asking for?
So under New York law, once a person reaches the age of 18, they are entitled to privacy rights. HIPAA applies, for the educational law applies. Nobody can access their financial information. Parents can't do any of that once a child turns 18, right?
So
how do we become an adult?
Why not ask for a protective order? Why not go in and say, I've got this panoply of rights. I have the right to not have my father see my health information. I have a right for my father, all those things. Why not just go in under and seek a protective order to protect all that privacy?
This is what the judge tried to do here. She requested that the permanency hearing report, in this case, be redacted. It was redacted. They came to court. It contained very little information. In permanency hearings, the services that the child receives from mental health services, medical services, educational services are front and center of these hearings. They're supposed to make sure that the agency affords the child whatever.
You can do that with a protective order.
You can't if you can't have a discussion in a permanency hearing of these issues with a parent there. What happened
Counsel, another option, I'm sorry to interrupt you, but another option for a protective order would be just to reduce what the father could do with the information obtained. So what about that? Was that asked for below? In other words, a protective order saying you can only use it for the purpose of this hearing and for no other reason.
But as an adult, she's entitled to say, I am not consenting to the father learning this information.
Yeah. Just so I'm clear, I'm sorry, counsel, you didn't ask for a protective order below, did you?
We asked for the information to be redacted because
the health information, which was done.
Give us the relief. But then the hearing, if you look at the record, it became a circus because no testimony could be given. The child couldn't ask for services that she wanted because the father was there, and a lot of it was protected.
Couldn't you do that, some of that in camera? I mean, going forward, we are not unsympathetic, but we're trying to figure out, couldn't you ask for in-camera testimony for that kind of information to keep it keep it private?
But that is most of what permanency hearings are. What counsel for the respondent in this case suggested is that they said, let's go off the record and do it all off the record, but that defies the whole idea of having permanency hearings and issuing orders that require services for the child and holding the agency accountable. This is all information that needs to be litigated and discussed during the hearing. Now, when the parent is there and the rights of the child to privacy are violated, you can't do any of that.
No, but why can't you do it in camera? Why can't you exclude during the testimony anyone in the courtroom or close the courtroom or do things like that? Wouldn't that be one way that you could comply with the statute but also preserve your client's privacy rights?
But this is the thing, there is no purpose for the parent being there. The parent no longer has any due process rights for an adult.
Save for what apparently is imbued by 1089, right? It's the peculiarity of the language and the definition of the child for the purpose of 1089 that puts your client in the position that the child finds.
Well, the legislator, what seems to be an oversight, they failed to draw the distinction between adults and children and persons under the age of 18 for purposes of these permanency hearings. But what is created is an unworkable situation where you cannot hold a hearing, you can't help the child, which is really what the family court is about and what the permanency hearings are about. It's about helping the child.
Also, you do make that point very well in your briefs. Thank you. You have time in rebuttal.
Good afternoon, Your Honors. May it please the court. I'm Ann Reiniger, and I represent the father, Roman de Jesus, the father of Parvati, the child in question. After the court made its decision, it held a permanency hearing. And in holding the permanency hearing, it modified the permanent plan to the independent living from return to parent, and it adjourned the case. And it said that my client's daughter is so angry at her father, but she's in foster care in the custody of the state, and my client has parental rights, which include the statutory right to participate in the permanency hearing. And there has been no showing that he has used any of the information to harm the girl. And in addition, the court using
What if there
its
was,
authority in the
counsel, I'm sorry to
Family Court
interrupt you, but
Pardon?
I'm sorry to interrupt you. What if there was information that a parent was using such information that he gleaned from the hearing or from the report that's going to be introduced at the hearing and used it in a way harmful to the child? Does the court then have the discretion to somehow bar the father from either attending the hearings or receiving the report?
No, there is no discretion in the court. The black letter law is clear. The father is a party. The father is entitled to notice of the hearing and a copy of the report. The court did redact the HIPAA information under its authority under the Family Court Act 1047. And, but the hearing did go through and an adjournment was made. The neglect case, this family's case, is still under the court's jurisdiction.
In what other context, other than an individual who is incapacitated, would a person over the age of 18 who does not want their biological parent to know this sort of information be required to provide that information?
If they were not in foster care, sure. But she is in foster care. She consented to be in foster care, to continue to be in foster care, to reap the benefits of being in foster care, which are many, but also to comply with the rules. And she is in the custody of the state at this point. The court has the authority to deny, like a former foster care parent, to be present and to participate in the permanency hearing.
In this sort of situation,
the court has no discretion.
In this sort of situation, putting aside the statute, which of course only for a moment because it ultimately, controls, but what interest does the father have here?
He is still her father. In fact, the agency that is working with his daughter still has an obligation to try to arrange for visits and to provide services. And the statute also says that if parents' rights have been terminated, they have no right to be part of the permanency hearing. But that is not the case here. He is still legally the father.
Can the parental rights be terminated for an individual who's over 18?
Not over 18, but under the age of 18, they have termination of parental
The
rights.
child is sort of stuck. If the child wants to be in family court for whatever reason, they can't seek termination of parental rights, or the ACS or whatever appropriate body couldn't seek termination of parental rights because the child has turned 18. And so that puts the child in the position of staying in foster care or leaving the foster care system and the protections it offers.
As the appellant said, she is an adult and she has to consent to continue to be in foster care. And part of the requirements, she has to be in school or she has to have a job and she has to comply with the rules of the state so far as foster care is concerned. This statute was enacted in 2005, and this is a case of first impression. There has never been, we haven't found any cases, not, the judge, the appellant, or myself, where a child did not want their parent to participate in the permanency hearing, and they were.
What about
that was
counsel's argument that you really can't have a permanency hearing because she's really not able to communicate what her wishes are, what services are needed?
Excuse me?
What about her counsel's argument is that if you allow a parent to be present, then there really isn't a permanency hearing because there cannot be a free exchange.
We had a permanency hearing. The court held a permanency.
No, I know you
the
did.
father present. And there was enough information. The report was introduced. There was no information about her medical care because the court did redact that from the report. But they talked about how they were helping her get housing, they were helping her get a driver's license, they were helping her get driver's training, they were helping her look for her passport because she wants to become an American citizen. So all of this took place in the presence of the father, and there had never been any history of the father interfering with his daughter while she was in foster care.
Thank you, counsel.
Just briefly, the child, by consenting to remain of care, if the father is allowed to be there, is essentially penalized for staying in foster care. It penalizes her and gives the father, who had neglected her, greater privileges. It diminishes her rights of privacy and her rights to determine who is involved in her life. And with respect to this hearing, I encourage your honors to go look at how the hearing transpired, because information was redacted. Respondents' counsel then came in and said, well, I can't participate in the hearing because the entire permanency hearing report is redacted, so I don't have enough information. Then when it was suggested that he be excluded from the courtroom for those types of testimonies, he said, well, I can order the transcripts. I'm a party to the hearing.
I guess this goes back to something I think that we've shown some concern about. How could we, or can we, or could the family court more aptly, give your client the relief your client is seeking, but do so consistently with Family Court Act 1089?
Well, I would ask that this court read a requirement for consent by a person over 18.
But you agree there's none in there. The statute doesn't have it.
Because of the level
Don't
of...
we usually leave it to the legislature to do that kind of stuff?
Yes, but there is such a conflict, such a trampling over the child's rights. It creates such an absurd result, and also makes the permanency hearing, which is the center of 1089, completely unworkable, that it just cannot be that this is what the legislator intended. So if your honors would read consent into the statute such that a person over the age of 18 their consent is needed for their parent to participate, then that would resolve all the issues.
Your friend did. Go ahead.
I just worry about the precarity of anybody who wants to stay in foster care. I'm not saying your client in particular, but somebody who wants to stay in foster care after 18 could be in a precarious situation, and maybe they're not making the best, I'm not saying this is your client again, but maybe they're not making the best decisions about their lives. So maybe there should be at least some kind of good cause shown, which means a factual finding, which means that we'd be like engrafting something whole cloth onto the statute to exclude a father. You know, in other words, I can't say from a policy point of view that we can just say upon the withdrawal of consent of the over 18-year-old person that the father or any other parent, biological parent, or whatever parent is defined, may be excluded simply upon consent. I don't know if we can do that. I mean, that's really like we're taking a statutory scheme to help, you know, by definition, a population that's often in peril.
But every other adult at the age of 18 would be entitled to exactly that. Their consent would be.
I know, I'm saying that the fact that they're in foster care, that's what makes the difference.
It makes a difference only in the sense that the state is required to help them until they turn 21.
I totally understand this policy argument, but it seems to me a policy argument, one that we can't really get into because we'd be altering a statutory scheme in a kind of profound way, it seems like.
There is no other way to make this workable.
Or maybe we go to the legislature and say, we need to fix this, right?
This will
That
take
makes
time.
sense.
In the meantime, you have many, I mean, the judge notes on the record that she's had many cases in which young adults have asked that their parents not participate, and in many cases, the parents respect those wishes. In this case, the father has not participated in any services, has not done anything for this child. The child doesn't want him to be involved. He keeps coming for the hearing, and there's nothing that he can effectuate. He sits there just for the purpose of being there. And this is inconsistent with anything that is in my client's best interest or in the interest of these vulnerable children with their abusive or neglectful parents.
Thank you, counsel. Thank you both. Sire Spirits versus Beam Suntory. Okay, plaintiff, thank you.
Good afternoon, Your Honours. May it please the court. For the reasons we set forth in our papers, we maintain that the court below erred in dismissing several of the plaintiff appellant's claims.
Should we start with the apparent authority of Michael Caruso?
I'm sorry, Your Honour?
Should we start with the apparent authority question?
Sure. There were three questions I wanted to address, and that's one of them, so I'll be happy to, Your Honour. We clearly alleged a claim for apparent authority. Mr. Jackson, the principal of Sire, was seeking about looking for an introduction to the alcoholic beverage industry because he perceived that that was an area that would represent a good investment of his time and money. He met Michael Caruso, who said, you know, I'm connected to Beam. I'll be able to introduce you. They're one of the biggest companies in the world.
But it's true that the principal has to evince apparent authority, not the agent, correct?
And the principal did, Your Honour. Caruso introduced Mr. Jackson to Mr. Grant, who was at the time, vice president and subsequently became chief commercial officer of Beam. And in his official capacity, Mr. Grant said that he had a 20-year partnership with Caruso and told Mr. Jackson that he needed to work with Caruso or work through Caruso if he was going to work with Beam.
Is that too vague? It's not too vague, obviously. You're going to say no.
It's not too vague.
It seems a little vague to me. So what else you got besides those statements?
Well, subsequently, once the initial decision had been made in the meeting with Mr. Grant to proceed and see if something could be done here, Mr. Grant and Mr. Caruso worked hand in hand in various activities connected with the activations. Activations is a term of art. The public appearances by Mr. Jackson at nightclubs, bars, other venues where there was a public promotion of FN vodka, which was the product that was the subject of the brand collaboration agreement. Mr. Caruso was also acting hand in hand with other, lower level employees of Beam in terms of making sure that there was vodka product available at those locations, that the distributors, Beam's distributors brought them there. All of that was being done with the active participation of employees of Beam. So based on all of that conduct, and based on the fact that this conduct was not required under Mr. Jackson's obligations under the brand collaboration agreement, he had every reason to assume that Beam's conduct...
Why wasn't it? I mean, it seemed like he hired Caruso precisely for the reason that Caruso be a go-between him and Beam. So it seems like it is part of his deal with Mr. Caruso's corporation, no?
Sorry, are you referring to the agreement, the initial agreement between
Mr. Jackson hired Mr. Caruso to be a go-between.
He hired, well, one of Jackson's companies, G-Unit Brands, hired Caruso to be an initial, to participate initially in the arranging matters with Beam. That was until the thing got up and running and off the road. Then Sire Spirits was founded, and that was the Jackson entity that was involved primarily in the brand in performing Jackson's obligations under the brand collaboration agreement. And Caruso was not retained by Sire Spirits, and he was performing all of these duties that were not within Mr. Jackson's remit, but doing it in collaboration with Grant and other employees of Beam, and it was perfectly reasonable for Mr. Jackson to assume that that meant that he was acting on behalf of Beam, because Jackson wasn't paying him.
Let's talk about, briefly, another Caruso, Ms. Gina Caruso. It seemed to me that your complaint is very attenuated concerning her role in all of this, and she was correctly dismissed.
With Gina Caruso, we allege, again, this is at the pleading stage, Your Honor, and we allege that she participated actively in the affairs of MCF and G2J, two closely held companies that she and Michael Caruso hold between them. They are the principals, she's the vice president. She was engaged actively.
Where is the scienter here in terms of, all she did was just mail some invoices for her husband? Where is the intent to be part of this conspiracy with the price differentials, with the suppliers from France, et cetera, this whole...
She was, the way that one part of the conspiracy worked is that Mitchell Green sent fake invoices to the French suppliers, and then they kicked back, most of the proceeds of those, of the inflated price attributable to the fake invoices. Then the Caruso's company, MCF, invoiced Green for their share of the fake invoices. She was the one that prepared the invoices, sent them. She ran the checking account for MCF. So we're entitled to the inference that she knew what she was doing.
No. This is a heightened pleading standard for what this is not, what inference and what facts, other than she mailed these out and prepared some checks. What facts have you alleged to show the conspiracy, or that she was part of the conspiracy?
Just her active participation.
That she's alive and breathing?
Oh, she was.
No, but you can't just say she is participating without some factual backup for it. And it's fine if your only factual backup is she sent out some invoices. If that's your factual backup, that's what it is. But I would be shocked if you think that we wouldn't think that's enough.
I see the red light has gone on, Your Honor. So
please, you can respond. I'll give you 30 seconds.
I'm sorry, Your Honor.
No problem.
No, well, our facts are as they're stated in the complaint, that she didn't just send out some invoices, she actively participated in the back and forth with Green in terms of sending out the invoices and receiving the payments. But seeing as the red light has gone on, I want to make one other point about Gina Caruso. And that is, even if the court decides to uphold the dismissal of the 3 fraud-related claims, we think that the court erred greatly in dismissing the unjust enrichment claim, because she dismissed the unjust enrichment claim as duplicative, but it's not duplicative of anything, because the court had already dismissed the fraud claims, and there was no daylight in terms of between the Carusos in terms of where the money ended up. It ended up in their joint household account.
You can talk at greater length about unjust enrichment on rebuttal.
I'm sorry, Your Honor?
I'm sorry. You can talk at greater length about unjust enrichment on the rebuttal.
Unjust enrichment.
No, I mean on rebuttal. In other words, you
Okay.
get to come up again for another 2 minutes, and if you want to address it, you then.
Seeing as my time is
Yes, your time is up, but that's why you should sit down.
almost, oh, it's up.
Thank you. But you do have time on rebuttal, counsel.
Good afternoon. May it please the court. I'm Stephen Mullo, and I represent Beam Suntory. I'm going to address the question of apparent authority that you raised, Your Honor, and punitive damages. And Mr. Fishman will address the issues about Gina Caruso and attorney's fees to the extent they come up. Your comment, Your Honor, was spot on. The question in apparent authority is what were the acts of the principal? And here, the complaint fails to plead that Beam said anything or did anything that would have indicated to a reasonable person that Caruso was its agent. In fact,
at some point they started paying Mr. Caruso, but you have an explanation for that.
So the payment of Caruso, it's very misleading in the complaint. The payment of Caruso occurs because at a certain point in time, they modify the agreement between Sire, Jackson's company, and Beam to allow for the payment and to have Caruso perform certain duties that were to be performed by Sire. So in other words, it's an assignment. And there's actually a signed document, I believe it's record 239, that 237, excuse me, paragraph 3, that makes that clear. And it's actually signed by Curtis Jackson, the principal and the owner of Sire and this LLC. So the fact of the payment really doesn't matter. The comments that they make about what it was that Grant said in this meeting really are of no moment. The sequence of events here, I think, tells it all. Caruso goes to Jackson, Sire's owner, and says, hey, I can get you a liquor deal with Beam. I can get you this endorsement deal. And sure enough, I have close relationships with Beam, he says. That's what's alleged in the complaint. He then brings Grant to meet him, to meet Jackson, and they talk about doing a deal. And yes, Grant says, this is my man, and we've known each other 20 years, we've done business together. He's going to be essential to the relationship. That's what's pled. But what happens after that? After that, they enter into the agreement where Caruso is going to be the agent for the representative of Jackson and of Sire. So, I mean, no one in their right mind would have gone through those two meetings and then signed an agreement and said, you're going to be my agent, and said that, well, no, but what you said in those two meetings really made me think that you were Beam's agent. So that, there's just no question. I mean, Justice Crane got it right, and she said no one could reasonably believe that that Caruso was acting as Beam's agent. I want to touch on the punitive damages point as well. On the punitive damages point,
There's been no public harm here, sir.
there's no public harm, and there's also no pattern. So, the case that is central to this, the Court of Appeals established the law in the Ronkonkova case, which interestingly too, it emanates from contract just like this did, but there were fraud allegations. The allegations in Ronkonkova weren't actually contract allegations, they were fraud allegations, like the allegations here. And so there's no, the three-part standard: is there egregious conduct? Is there a pattern of misconduct? And was it directed at the public? And that's simply not met here. This is a private transaction. It was a kickback scheme alleged in connection with a contractual relationship. The word agreement is used 127 times in the complaint. Paragraph 1 of the complaint says plaintiffs were induced to enter into various agreements with Beam. So it's clear that this emanates from a contract, and as a result, the Ronkonkova test applies. That test is nowhere close to being met here. If there are no further questions, Mr. Fishman.
Could I just ask you to address the unjust enrichment?
On the unjust enrichment, Mr. Fishman is going to address that too.
Oh, okay.
Thank you.
Oh, okay. Thanks.
Thank you very much, Counsel.
Was there anything else?
I don't think so.
Okay,
Thank you very much.
Good afternoon. May it please the court, Paul Fishman from Arnold and Porter on behalf of Michael Caruso, Gina Caruso, MCF Consulting, and G2J Brand. If I could, Justice Schulman, I just want to respond quickly to your question. It's not just no public harm. Honestly, I was a prosecutor for a long time. Kickback scheme is a kickback scheme, but it's not an egregious offense within the meaning of the punitive damages cases. It doesn't rise anywhere near to that degree of moral turpitude. So they fail one more test on the punitive damages claim. If I can, let me quickly respond on the Gina Caruso point. All of you who asked questions got it exactly right. There's not enough in the complaint to tag Gina Caruso. She is married to Mike Caruso. We're all familiar with lots of people who in their daily lives have a spouse who sits in the dining room or the basement or the bedroom and helps with paperwork. That's what happens. That doesn't make somebody liable for a fraud. But not only have they not proved, not only have they not alleged that she knew, they also have alleged absolutely no reliance because the invoices that she allegedly typed and mailed went only to Mitch Green. They never went to Sire Spirit. So there's nothing that she did upon which they relied at all. And Justice Scarpella, with respect to your question, you have to have some fact alleged about how they relied on Gina Caruso. They didn't even know she existed in this alleged scheme whatsoever. So with respect to the unjust enrichment, Mr. O'Kelly made a misstatement. The money did not, in the complaint, it's not alleged to have gone into their household account. It's alleged to go into the account of the corporation, MCF, that Mr. Caruso owns. She is an officer, but what they're asking for unjust enrichment is to have it be enough that someone who is a spouse of...
So you're saying that she's not a shareholder of that?
There's no allegation.
There's no allegation that she's a shareholder.
That's correct.
So it's only out of his largesse treating his wife nicely that she could have been unjustly enriched from money that went to the business account.
It's possible.
It'd have to have first come to him, and then he'd have to have spent it on her, and none of that's in the complaint.
None of that's in the complaint. They're free to take discovery on that question, of course, to see what happened to the money. That's fine, but it's not enough to sustain a claim of unjust enrichment at this point. I want to talk very briefly about the attorney's fees issue. In this case,
That involved the arbitration proceeding.
Correct. In this case, Sire Spirits made what turned out to be a terrible economic decision. They spent $1.5 million on attorney's fees in an arbitration to get a $6 million judgment against someone who was judgment-proof. And now, because they spent that money, they want to see if they can recover those fees from Mr. Molo's clients and from my clients. And there's no basis for that under the law. As alleged, Mr. Caruso and Mr. Green are alleged to have been joint tortfeasors. It can't be that the fortuity of your responsibility for attorney's fees turns on the order in which the plaintiffs chose to sue different alleged joint tortfeasors in different fora. If they had brought this case in 2018, before Mr. Green became an employee of Sire Spirits, when he was still just a consultant, they wouldn't have had an arbitration agreement, and they'd be sitting here at the table with us in this particular litigation. And there's no basis to invoke the exception that is presumed under New York law, that people do not bear the cost of other people's attorney's fees in the absence of proximate cause. What's the proximate cause they allege? That Mike Caruso and Mitch Green were in a conspiracy together. It's not a situation, as I'm sure this court has often seen in the case law, where one of the joint tortfeasors or a prospective or actual defendant takes property and puts it beyond the purview of the court, or engages a financial transaction that causes something causes the plaintiff to have to bring yet a separate proceeding. This is just the fortuity of Sire Spirits happening to have an arbitration agreement with Mr. Green and not having an arbitration agreement with Mr. Caruso. That doesn't put Beam or the Carusos on the hook for the attorney's fees in this case.
Thank you, counsel.
Thank you.
I'd like to first address respectfully the question of the public interest. And there's ample case law that says that when conduct is egregious and basically criminal in its nature, that it can satisfy the public interest requirement. There's a case from the Court of Appeals from 1976 called Borkowski, which overturned a decision by the Appellate Division that punitive damages would not be allowed in a fraud case only when the acts had been aimed at the public generally. Sometimes the egregiousness will bring it to the level the level required. We cite the Mulefield v. Back case, which involved conversion of jewellery where there was a single victim, and the court applied or imposed punitive damages because crimes of this character are directed not only at the victim but also at the public. Surely the protection of society from thieves ranks among the most important duties of the state to its citizenry. There is a similar situation in the Clark against Castor and Pollock's case. Again, one victim.
But counsel, I mean, it just seems so much that the behavior of Mr. Green and what he did vis-a-vis Mr. Jackson and his companies was so directed at Mr. Jackson because he was a moneyed individual and he was embezzling from him, and not against the public. It was against a particular, he had a particular mark, unfortunately, Mr. Jackson. So in other words, it doesn't affect the public. It's a private wrong.
But like the cases that I cited, it may have been aimed at a single victim, but it was an all-encompassing scheme involving criminal activity in 2 countries.
No, but that just seems to open the door so broadly to the possibility of punitive damages in so many different kinds of fraud cases. I want you can draw it to a close, and I'll give you a little more time, please.
May I just finish on one note? Mr. Fishman misspoke when he said that this was not egregious. In fact, the court below, Justice Crane, held that the conduct here was egregious.
All right, thank you.
Thank you.
Any other questions? Thank you very much, counsel. Thank you all. Okay, the next case is Torres versus Levy. Justice Shulman is recused. Okay, counsel.
Good afternoon, Your Honors, and may it please the court. Justin Tan, on behalf of the appellants, Dr. Amit Kalra and Dr. Daniel Basilelli. Let me begin, Your Honors, by being clear about what exactly it is that we are seeking, that the court's decision below should be modified, and that the medical malpractice causes of action against the appellant should be dismissed in accordance with their motion for summary judgment pursuant to CPLR 3212. Well, I know that this court is familiar.
You want the complaint dismissed with respect to them via summary judgment?
Correct, Your Honor,
Right.
yes. Well, I know that this court is familiar with the record. It bears repeating. Dr. Kalra treated the plaintiff 1 time. Dr. Basilelli treated the plaintiff 2 times. Neither of these podiatrists assisted, participated, or were involved in the podiatric surgical procedure that was performed by Dr. Levy, who is a co-defendant in this case, and which is the crux of this medical malpractice action. Neither of the appellants treated the plaintiff prior to Dr. Levy's surgery, and neither of the appellants consulted with Dr. Levy prior to the surgery. Quite simply, Your Honor, the lower court failed to recognize that the expert affidavit that was submitted by the plaintiff was really an expert affidavit that was submitted in opposition to the motion for summary judgment by Dr. Levy. So much so, Your Honor, that when looking at the expert affidavit that was submitted by plaintiff as it relates to the appellants, there was a specific portion that stated specific disagreements with Dr. Michael Treppel. Dr. Michael Treppel was the expert that was used by Dr. Levy in support of his motion for summary judgment. The appellants had used the expert affidavit of Dr. Edwin Wolf. And notably, within the plaintiff's expert affidavit, there was not...
I noticed that even if they were supposed to, in this course of
Yes, Your Honor.
45 minutes, and then to diagnose the RSD, there isn't anything in the plaintiff's affidavit that explains how that approximately caused the injury, right?
I'm glad you noted that, Your Honor. In regards to the proximate cause argument, I'd urge this court to look at the Rebozo case, where in the Rebozo case, they specifically note in a case that involves RSDS, the court in Rebozo actually addressed the proximate cause, even though it already held that there was no deviation from the standard of care. And in Rebozo, the court specifically held that in any case that involves an injury involving RSDS, the expert must establish that even if it had been diagnosed earlier, that the plaintiff's expert must show that the symptoms of RSDS would have been less severe if it had been caught earlier. And here it was missing. And unfortunately, the court below, in rendering its opinion, didn't seem to address the proximate cause argument. I'll submit to your honors here today that the expert's affidavit that was submitted by the plaintiff did not address the proximate cause argument. There was not one expert opinion that specifically noted that even if it had been diagnosed earlier, that the symptoms of RSDS would have been less severe.
Was there any identification of any symptoms?
Yes, Your Honor. In relation to the symptomology of RSDS, it's almost like a catch-all injury, where it's related to a pain that comes from nerve issues. Here in the expert affidavit that was submitted by the plaintiff, there was not one expert opinion that specifically noted how Dr. Basilelli or Dr. Calra missed the diagnosis of RSDS. There was one paragraph that lumps in Dr. Levy, Dr. Basilelli, Dr. Calra, which is contained in paragraph 52 of the affidavit, which just states in the conclusion that RSDS should have been diagnosed. But there was not one opinion differentiating how the treatment by Dr. Basilelli or Dr. Calra, how they missed an RSDS diagnosis. That was not present within the expert affidavit that was submitted by the plaintiff.
Thank you very much, counsel.
Thank you, judges.
Davis versus Schlayer. Please, counsel.
May it please the court, Lisa Florio from Abrams Fensterman for the appellant, Mr. Schlayer. Mr. Schlayer should never have been knocked off the ballot here. This is unprecedented and draconian based on a hyper-technical rule about verification that he was even unaware that he was being held to. He was never notified of any problem with his verification, on his answer.
Right, was the answer rejected as required under the CPLR, right? If the answer is, you have to actually do something to say that you don't want the answer if it's
Right.
unverified, right? Did that happen here?
No.
Okay.
He had-
Did anyone raise in front of the court below the unverified answer?
No.
The fact
Your
that the
Honor.
answer was unverified?
No, Your Honor.
Okay.
There was a series of emails between counsel and Mr. Schlayer. There was an affirmation on service submitted to the court by counsel, not served on Mr. Schlayer, who was not on NICEF. He didn't have the ability to do that, which is why he did not upload an answer to NICEF and was sending a process server to serve counsel.
Okay, so then let's turn to the other sort of technical requirement. What happened with serving?
What happened with serving?
In other words, was the default granted because service was late of the
No.
answer?
No.
Well, okay. That's, okay, so you didn't answer initially within the time period or your client didn't, I should say, right? So he defaulted. And then what happened after that?
He appeared in court, and the court gave him, although we don't have the transcript, we have ordered it, we don't have it. But the court gave him, from my understanding, until 8 p.m. to serve counsel at his home.
Is there an affidavit from anyone that says that that's what happened in court? Your client was there?
No, he had no opportunity to do that because
No, was your client in court that day?
during the day when he was directed to.
When he was directed, right?
He was
So
directed to serve by 8 p.m.
How
that
do we
night.
know it was by 8 p.m. by home, by counsel's home?
The case was dismissed the next day. He
No,
never
I'm
even
asking you,
had-
how do we know that that was the service requirement?
Oh,
I mean,
Well-
I tell you from your reply brief, it sounds like that counsel agreed that he was going to sit in his house till 8 o'clock that night.
The only thing we have is counsel's representation in document number.
Well, your client was there, right?
Was where, Your Honor?
When the service the extension of service occurred, correct?
The case was dismissed the next day based on the verification. He had
No,
no-
counsel, I'm
Yes.
sorry if I can jump in a bit.
Yes,
Let's focus on the actual day of the default. Your client was there, he didn't put in an answer, and the court, with or without a reporter, said, I'm giving you more time to serve an answer, correct?
yes.
Your client understood from that court appearance that he had a direction. On a certain day, he was supposed to serve his answer to Mr. Newell on behalf of the petitioner,
Yes,
home somewhere on a certain day at a certain time, correct?
yes, Your Honor.
Okay, so now on that day in question,
Yes,
calls were made, as I understand on the record.
yes,
He called and said, where are you? I'm trying to track you down. So Mr. Newell was tracked down to some restaurant in the Lower East Side.
correct.
Okay, so he knew he was under the gun to try and get his answer to Mr. Newell, correct?
Yes,
Okay, and what happened was, and it doesn't appear to be undisputed on this record, your client was late. He served him 7 or 8 minutes after the 8 o'clock deadline.
I don't think it's undisputed on this record.
That's right, it's undisputed, so he's late.
No, I don't think it's undisputed.
Oh,
mean, I
you're
think-
saying
I
he
think
served him before 8 o'clock?
He was, by my understanding, and when we get the transcript.
Again,
Yes.
do you have an affidavit from your client or anything? I mean,
When would
did you put
he
in
had no
anything?
opportunity to put
You
in
just put
an
in
affidavit?
this giant brief.
Yes,
I'm asking you, is there an affidavit from your client saying what you're alleging in this brief?
his case was dismissed based on.
It's a pretty straightforward question,
Okay.
counsel. The answer is, did your client put in an affidavit stating all of the things that you argue in this brief about how there was somebody hiding in the bathroom, the whole thing?
He did not know even that
Did
his
anyone
answer
put in
was
anything
rejected.
like that?
No, but he had no knowledge that his answer was even rejected.
Who was the person who did the actual service?
A process server,
Uh-huh.
yes, and she would be able to put in an affidavit. It's just the case was dismissed based on the verification. He had no idea that his answer was being rejected by the court, and it was not rejected as untimely. It was rejected as not verified.
On this record,
Yes,
please correct me, after the claimed service on Mr. Newell in the restaurant at whatever time Mr. Newell claims he got, which he claims was late after the 8 o'clock deadline, was your client aware that a communication was made to the court, because that's part of the record, that service did not comport with the judge's direction to be served at 8 o'clock?
yes, and
He was aware of that?
he responded by email.
Okay, so we have an
reason why,
awareness.
Which is in the record.
Right, so it's in the record.
Yes.
He was certain that Mr. Newell said as I guess as an officer of the court, but based on his representation to the court, Mr. Schlayer did not meet that direction of the court. So from petitioner's point of view, there was still a default. From his point of view, would you agree with that?
At 8:01 p.m., he
Well,
emailed
whatever
the court
time,
and
I
said there's a
don't
default.
know exactly. Would that be fair?
It's fair.
Okay, so now we're confronted with the actual order of the court. And from what I'm gathering from your appeal or your brief, the whole issue of the verification was something that was sui sponte.
It was not something that,
That was raised below
appellant was
and your side,
aware of.
was raised by the court,
yes,
correct? As a basis for rejecting the answer.
apparently, yes.
I'm just reading what the
Yes,
judge's decision
yes,
was.
Your Honor.
And then the judge's decision ultimately said, so therefore I find Mr. Schlayer to be in default. He granted a default judgment dismissing the petition. Is that the language of the court order?
Based on the lack of verification, correct.
So it's a default. Okay, so now we're going to cut to the chase. Based on my understanding of well-settled case law, if there is a default, regardless of what triggered the default, is there a basis for an appeal, or should one have to have first moved to vacate the default and then say, Judge, you had no right to reject the answer. There's no strict requirement for verification under the election rules, and all the arguments that you raised in your brief, and particularly in your reply brief, because the whole issue of the default argument, I don't recall from the initial brief, but okay. Do you follow what I'm saying? So what's your position on that?
Absolutely. Our position is that he did serve an answer. He did appear. This is not your typical default where someone doesn't appear at all. This was not a default. This was like the case law from the Fourth Department that we cited where the question is, did the court properly reject the answer as not verified? And for that reason, we do not believe that this was a default situation where Mr. Schlayer had to move to vacate it, then to be able to appeal from that order, no. So,
I'm sorry, but
yes.
what was the service directive that was given for the answer?
To serve counsel by 8 p.m. at his residence. And then in court, now I don't have the transcript. I am representing what I understand to be what happened.
Well, so that, I guess that's really the question.
Right.
Is there anything that would, anyone with personal knowledge on your side that would say that was the directive?
If he's permitted to go back and put in an
No, I mean, we
affidavit.
are where we are now. There was an argument on appeal about it doesn't matter, even if the answer wasn't struck, that it was untimely.
Well, our contention is counsel was supposed to be served at his home. He gave his home residence address to.
Let me ask you a different question.
Yes.
Did you file a notice, did you file an affidavit of service?
There is no affidavit of service filed. We can file one now.
No, I
he
mean, don't you
served-
have to file an affidavit of service when you serve? And you haven't done that. So we couldn't even go back to the record because you haven't filed an affidavit.
And also, wouldn't, just to follow up on Judge Scarpulla's question, you couldn't have a traverse without an affidavit of service, right? So, because some of the questions you're raising and you raise in your reply brief sort of lead me to the query, and probably others of us, why not have a factual a hearing about the circumstances of service? But can we even do that if there's no affidavit of service in the first place?
The case was dismissed the next day by an order. Our client didn't even know about it for 4 days. He didn't serve him for 4 days with the court's order.
But once you effectuate service, you file an order. I mean, were you his attorneys at that time?
No, but he was pro se. He is not on NICEF. He would have had to submit the document at the next appearance. There was nothing. The case ended. So he was not alerted to any of these problems. He didn't even receive the document number 12 where counsel asked to reject the answer on timeliness.
Why wasn't he on NICEF?
He's not an attorney, he's pro se.
I mean, anyone can go on
Well,
NICEF.
the short
My
amount of
mother-in-law goes
time
on NICEF.
My understanding is they discussed that in court. The judge said you won't have time to get up and running on NICEF. It takes a full day to be consented when you're a new person or something. Serve him in person at his home. And
Hey, Counsel, we'll give you a chance for more time in rebuttal as well. Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the court, Paul D. Newell for petitioner respondents. So if I can just address some of the matters that were just discussed. First of all, there was actually an affidavit of service filed or emailed at 11:09 p.m. When
Is that in the record on appeal?
it is, they did not include it. It was in an email. The court was copied. I was copied. It was in reply to my email at 8:01 p.m. This email was at 11:09 p.m.
You were in court on the day.
Yes,
that
I
day.
was.
All right. What is your, and I'm just asking you, I'm not making any value judgment. What was your recollection of what was said about service?
As I have said in my briefs and affirmed under penalty of perjury, the court ordered Mr. Schlayer to serve me with an answer by 8 p.m. He suggested that be personal service. I volunteered that NICEF was fine. I was busy that night. I didn't need to be, dealing with this.
Was there any specification that service would occur at your home?
No, there was not at all.
And personal service could have been leaving it with a person of suitable age and discretion at your home, right?
Or affixation after due diligence. But clearly, when your first contact is made at 7:36 p.m., 24 minutes prior to the deadline, due diligence is difficult to achieve. There was an affidavit of service in that email from a Ms. Maria Allen that merely says that she served me on April 25th at the Faux Grand restaurant with the address. There is no delineation of any of these unsworn and frankly defamatory
Does it say the time?
allegations.
Does it say the time?
It does not say the time. However, in that same email, Mr. Schley, the email written by Mr. Schley, copied to the court and myself, specifically says that I was served, that Ms. Allen served Mr. Newell at 8:08 p.m. That is specifically a sentence in his email.
Oh, he says he served you at 8:08.
Admits,
Okay.
he admits that in the email. He also attached a photograph. They took a photograph of the service, which I tried to smile for. That kind of cut my head off a little. Time-stamped 8:08. This is their clear admission.
Is
of
that
late
in
service.
our record on appeal?
It is, well, okay, so I filed last night or early this morning a motion to strike appellant's reply brief because it is shot through with unsworn and defamatory statements, which are not supported by the record. However, so it is.
It is consider such motion, but you can make the argument here.
Sure, and it is attached to that. I do have courtesy copies.
So
if the
it
court
is at some point. I'm just trying to figure out, does our record have that? Because, I mean, the fact is that the unverified answer striking, at least to me, is problematic.
So it is true. We did not.
You didn't do what this right
within the time under 3022.
And so then you essentially waived that.
Well, the court brought it up and notified him. I do want to add that, Mr. Schley and counsel suggest Mr. Schley was not on NICEF and he's some pro se litigant. Mr. Schley has a JD, as litigated before this court and before the court below numerous times, has run for office numerous times, and is on NICEF, has a NICEF account at which he's filed more than a dozen papers before this court and the New York County Supreme Court. For one example, and I've just got a notice here, and the filing user, Craig Schley at schlayforassembly.com, in the matter, Craig Schley versus Board of Elections, 2020-02524. He filed 5 or 6 documents via NICEF there. And
let me just ask you this: assuming that you agree that you didn't do what the CPLR requires to nullify the unverified answer, and so if we assume that the default was not properly entered, I'd like to hear your view on, should we send it back for a hearing on untimely service, or is there anything in the record now? Can we make a record on that? Is there enough of a record?
The untimely service is beyond dispute. Again, it is directly admitted
in the record
on appeal. Yes, in the record on appeal, in an email from which I filed as NICEF Doc 12.
And you below, in the court below, raised this issue. It's not an issue raised for the first time on appeal.
So it was raised in my email at 8:01 p.m., which is attached to the affirmation filed later that evening. At NICEF Doc 12. That email includes, apologies.
No, I'm sorry. Is there any prejudice by this delay?
Yes, in election law, there is always prejudice by delay, both to petitioners and to the board. These matters are litigated under very high speed. And
we're talking about 8 minutes of delay.
No, okay, but every election law part in New York City requires litigants to have papers in by the return date. So for respondents, that's the answer. For petitioners, that's usually a bill of particulars.
He got extra time, right? He missed the first one.
The court
got extra time.
Correct, which is clearly within the court's discretion to grant, and did so. The court suggested that the service be personal only. asked if I would be at my office. I said I would be near my home or around, but I also said that NICEF would be acceptable, mostly because, I didn't want to be harsh, but also because I was planning a community Seder the following night for 65 people, and I needed to meet with my friend Alex Lee. I filed last night an affirmation from Alex Lee, who was present.
Sir,
Sorry.
I need you to help me out here.
Sure thing.
I'm very confused at how this all unfolded.
Sure.
You appear on the 25th.
Correct.
The respondent, Mr. Schlayer, I won't use petitioner respondent. Mr. Schlayer is given an extra 7 days to serve till 8 o'clock on the 20.
No, another 5 hours.
He was given till 8 o'clock on the 25th?
That same evening, yes.
Okay. So he's given till 8 o'clock on the 25th to serve. Okay, fair enough. Something then happens around 8 o'clock or a little after 8 o'clock. How then does this issue come to the court's attention regarding the timing of the service?
So he had been ordered to serve me by 8 p.m.
Okay.
He called me,
How did it come to the court's attention that the service occurred in whatever manner it allegedly occurred?
I sent an email shortly after 8 p.m. from the restaurant where I added the fact that I had been contacted to the court saying that I had not been served at that point, requesting.
Is that how that part operates with its election cases? That there are emails sent to the court to.
So they asked to email. I sent the email and copied the court on that, and copied Mr. Schlayer and counsel for the board as well. And later that evening, at about 10-something that evening, I'm not sure exactly, I filed an affirmation on NICEF with documentary evidence and detailing the exact scenario of events, and
that is on NICEF now.
Correct, NICEF Doc 12, and that includes not just my email, which I put as an attachment to that, but also Mr. Schlay's reply, in which he explicitly says that I was served at 8:08 p.m.
Okay, so all this information comes into the court by these means, and like you mentioned earlier in your argument, this is a very tight time frame we're operating with, so understandable, we got to sort of adapt. In response, the next day, the court issues the order we have here, where it now says it doesn't address service and just says there's no verification, so I'm treating this as a default and then dismissing or granting your petition.
Correct, Your Honor.
Okay.
I know I've got a red light. If I could just address 5511
Go ahead.
briefly with regard to appeal. The matters with the Pridgeon and Augustini that counsel refers to. These are the Fourth Department matters that she refers to.
Let me just ask you, yes, we all know that you have to move to vacate. Is there time to do that in this case?
Well, they waited 10 days from the decision to file an appeal. Surely there would have been time, and election law matters are expedited. New York County, wisely, in my humble opinion, sets a specific election law part. I think other counties could follow that lead, but so that they're fully aware of the time. There were other matters going on. I appeared the following day on 2 other matters before Justice Lattin.
But your petition was contested by Mr. Schlayer.
Mr. Schlayer appeared.
Okay, and he put in arguments one way, shape, or form. Whether they are cognizable due to want of a proper answer.
No, he didn't really. The discussion was really the appearance was quite brief. There was discussion of an answer. The court felt that without an answer, it couldn't. Justice Lattin felt that he couldn't really move to the facts. And the motion and the decision was on default. That's clear in the order itself, and 5511 prohibits it. And counsel's argument that the default was the subject of the controversy below, therefore permitting an appeal, is tautological. Obviously, every default is entered on default, therefore, by definition.
If I make a motion against you under CPLR 3215, for a default judgment in a civil case, and you put in papers in opposition to that, and the judge sides with me and says you're granted a default judgment, was that default judgment entered on default?
So it's an excellent question, and it's going to the point that I was about to make, distinguishing the Pridgeon and Augustini cases, where there were motions for default, and they were argued at the court below. Those motions were argued at the court below, and a decision made, which the Fourth Department then overturned or reversed. That is not the case here. The court entered this motion on default because the court specifically ordered Respondent Schlayer to serve an answer by 8 p.m.
No, but that's not the problem with that, is that that's not why the court issued the default. The court struck his answer. It would be a different thing. The court looked at the answer and said, this isn't verified and or whatever, and it doesn't, that would be a different thing. That's the problem here.
No, Justice Lattin chose the verification option to rest his decision on,
Which I think you acknowledge because you didn't reject the answer on that ground, or you didn't send the notification that you had to send. It's problematic.
Well, again, the court notified Mr. Schlayer by issuing its decision, and that was within 24 hours. Though I will grant that petitioners did not raise it within the time frame required by 3022, 24, or what due diligence, whatever you define it as. But given that there were, I think a way to read Justice Lattin's decision is that this answer is a nullity, and it's a nullity, for two reasons. Though he cited the verification, and therefore there is no answer, and without an answer, default is in order.
Counsel, thank you very much. We'll hear it now.
Thank you.
Get the last word from Mr. Schlayer.
I'm shocked that counsel is allowed to talk about facts. We have the process server here and Mr. Schlayer. They can tell what they understood in the court. Mr. Schlayer can say what he was told in the court and where to serve.
Counsel's talking about things he filed under NICEF.
Okay, so there is a filed affidavit of service.
Okay,
There is one.
so we'll just look at that. That's right.
And the record on appeal is very sparse. There was no motion for a default made. There was no motion or any objection based on verification. There was nothing here. And he says that Mr. Schlayer knew 24 hours later about the court's rejection based on the verification. He didn't serve him with that order till 4 days later. There's enough delay to go around here. Yes, he delayed in filing an appeal because he had to find counsel that would take his case. The delay, the court should have gone forward, even making this determination, and gone by the line-by-line signatures to make that determination. He's raising in his brief that he's concerned about, there's delay and how are they going to get this done in time. There's a lot of delay here. The trial court should have looked at the signatures. That's what he was expecting to have, a hearing on his signatures. He was blindsided by this decision on the verification. He had no idea. He had no opportunity to cure it, or the court could have ignored it under 2001 and 3026.
So what is the issue, if there is any, vis-a-vis the service?
The service, when we're allowed to put in an affidavit of service, and Mr. Schlayer can put in his affidavit stating what the facts were, and when the transcript is available, that he is told to serve him at his home, and counsel is not at his home where he was told by the court to serve him, and Mr. Newell gave his card, it's on the record, gave his card.
There's a difference between saying do personal service and serve someone at home, right?
I believe the transcript will show the directive was to serve him at his home, and he wasn't there. And he had 5 hours when he was directed to serve him at his home from the time of court to get a process server to get the answer there, and he couldn't find him. 7:30 is enough time if you're a block away from the house to serve the man. He wasn't there. Otherwise, this dismissal is against the Election Reform Act. You're not supposed to knock someone off the ballot for a trivial purpose, and that's what happened here. It was a travesty of justice.
You rely on a couple of Fourth Department cases, don't you? Augustini,
Yes, Your Honor.
Atwood's sort of relied on both sides. But both of those cases say that they're going to ignore the default, correct? And they go on to reach the merits. There were defaults below, allegedly, or like, and Atwood, the trial court found that two of the petitioners were in default, but, quote, "We reached the merits of these issues they raised on appeal inasmuch as those issues were the subject of the contest below," which is probably a concept that needs unpacking. But anyway, they did, they didn't dismiss the appeal because of the failure to move to vacate the default below, correct?
Right, but they did determine that the answers were incorrectly stricken based on the verification, and they reinstated the answer, and especially in Agostini, the appellate division then went on to decide one of the affirmative defenses that was raised in the answer. So they not only reinstated it, you know, this was just unjust. It was very unfair. He didn't have notice. He tried to comply with the court's order to serve. The court didn't even make a finding that the service was
So
untimely.
the next step would be, if you prevail, I'm not
Yes,
saying
Your
you
Honor.
will, would be for a remand to go over the contested signatures, correct?
Yes,
I mean,
Your
the
Honor.
next step will be go to the Court of Appeals. I know you're going there
Or
first, but
default on the time, or default on the service, right? I mean, you want to contest. Counsel for the petitioner is saying it's undisputed on the record that you defaulted on service. You didn't timely serve.
There's no
Based on if there's an affidavit or a concession by your client that it came in at 8:08 and the service, the extended service was 8 o'clock, then I mean, at least it's not an issue that's gone, right?
was that would be another, what Justice Garpool, I understand her to be saying, is that that's also a factual issue that would be unpacked.
Right, there's no finding below that there was untimely service, nothing. The court, he presented it not in a formal motion. In his affirmation, the court didn't say, yes, I agree, this wasn't served as a, you know, maybe the judge agrees with Mr. Schlayer that he told him, and he was evading service. He told him to serve it at his house, and he wasn't there. I mean, you know, but to dismiss someone or knock them off a ballot based on these circumstances is completely unjust.
I'm sorry, just one last question from me. Do you know what efforts, well, either any efforts you yourself made or your client or anyone else to obtain that transcript from the 25th when the service directive was given?
Only now that we have been retained for appeal, we have asked for the transcript. We have reached out to found the court reporter and reached out to them. I don't know of any prior effort to do that, but Mr. Schlayer was pro se. So, but our understanding was that this court would pull the record below. We didn't know if the transcript would be there. We did speak with the clerk. They said the transcript is not there. So we ordered it. So.
Any other questions? Thank you very much,
Thank
counsel.
you, Your
Thank
Honors.
Thank you both.
Counsel, may I talk to you for a moment?
You can't use your phone. I know a lot of people interpret that. Well, texting and checking my messages. That means you're on your phone. We cannot allow people to be on their phones. Usually in some phones, they're actually turning work. Go outside. it is live streamed and recorded, so you need to go back and hear it again. You can. Just go to the YouTube channel, Television First Department, and you could be here just in case you missed anything. Thank you so much. I don't know if that was one of your questions. Television First Division. Well, no, go to YouTube, Appellate Division First Department, and then you'll see the live streaming, and you just go to today's date. You can watch the whole thing. You can actually fast forward to your case, whatever you want. It's good to know. Appellate Division First Department. Thank you for letting me know. On YouTube. On YouTube. Yep. Now, I know you said we can't text on the phone. Right. We can put it on vibrate, right? You can put on, that's what, like I would say, like my daughter's high school, they said you can't bring phones, but the principal said, if we don't see your phone, we don't know you have it. So, like I tell people, if you don't know how to shut off your phone, if it's on silent and it's in your pocket, we don't even know it's there. We can't text, but we look at it. Negative. Because if you take it out, then we don't know what you're doing. That's why